I always wanted to serve on a jury.
I'm really super excited to be here, so I really appreciate you having me. I'm looking forward to it.
Creating this whole trial daddy.
I want to give a big shout out to the 13th Jury Podcast and Brandi.
Yeah, I applaud you guys. Keep doing what you're doing.
That every time you run into Phil Barber, you should reach for it.
And then I just looked to the jury, and it's sort of like, look.
I was in the eye of the storm, and you guys were watching the storm.
Hey, if you're bored of work, come pop in and say, hey, Watson.
A ray of sunshine, and I love what you've done with your YouTube channel.
Good morning. Hello, jurors. Good morning. Good morning. Hello, hello. Come on in, take your seats. I'm still getting stuff pulled up. I am getting the sentencing pulled up. They haven't started it yet. I mentioned yesterday that we have, oops, pressing the wrong buttons. Pressing the wrong buttons. I tend to do that. I mentioned yesterday that we have Robin Howington's sentencing today. Why can't I get words out? Oh, lack of sleep. That's why. We have Robin Howington sentencing today. If you missed the Robin Howington trial with us, that is the one that was heartbreaking, absolutely heartbreaking. We ended up sending a card with support and well wishes to the gosh, I have so much stuff open. This is what happens when I get tired and finish working at 2-something a.m. Just leave everything open. We sent a card to the officer who testified in this because it was so sad seeing him break down on the stand. So I made on the website, this is the one where I made the tab where everybody could go in and leave comments and support and stuff like that for him. And then we sent him a card, and I wrote out the link for that part of the website. So he went and watched everything or read everything and responded and let us know that, you know, it meant so much to him and stuff, which was great. So this is one that was really sad, really, really sad. Robin Howington was convicted. This is in Tennessee. She was the 2-year-old. She said that her story changed so many times, y'all. For those of y'all who didn't watch it with us, her story changed so many times, which is... Air came on. It's hot today, so it's going to be on a lot. Sorry. But her story changed a lot as far as how she said that her baby, her 2-year-old, is it 2? Is he 2? I think. Got her gun, and she said at first, you know, that she kept it put up in the closet. Well, at first I can't remember which the first story was. How many do we count? 7 or 8, right? I don't remember exactly how many. But there were a lot, and it changed. I mean, first it wasn't her gun, and then she blamed it on, some random, a random black man that came in or something like that. I mean, it's just, and then it was like, okay, well, and then every time they would let her know, like, okay, we have this information, and we know for a fact that, this is your gun, or that this, registered to you or whatever. then after they would catch her in different things, then she'd be like, oh, well, yeah, it's my gun, but I told him to put it out. I mean, there were so many different stories. She was convicted of all charges, and she is facing her sentencing. So it should be starting any minute. So I've got, we're going to watch that first. Let's see. It was awesome. It was cool seeing how much it meant to him. He said that he read it, like 7 or 8 times, and that it meant so much to him, and he's going to go back and read it again and stuff. It was really nice. I was glad that our little community was able to have a good positive impact on him. Oh my gosh, the crying. Yeah, she would do the fake crying, and then she'd look, then she'd get annoyed, and during cross and stuff, and she would look, and she said over and over, she was, what was that thing she kept saying? I was trying to protect my kid by, it didn't make sense, but nothing she said made sense. Yeah, the woman that blamed her son for... Lucy's over there jumping around like a little gazelle. What are you doing? Did you get frisky all of a sudden? You got feisty? That treat kick in? Okay. I hear you. Maybe she'll give an 87 story today. Oh, I hope they don't let her talk. We heard enough of her when she was on the stand, didn't we? Not a fan. Not a fan. Good morning. Oh yeah, my screen. This is for those of y'all who haven't seen it yet. I've got a green screen behind me, and it's not going to stay up forever, but I put it on the other day, and I've just left it on because I just haven't had time to take it down and put it up. So it's still up. But this picture behind me, this picture behind me is actually my window that's over there, but but now it's just behind me instead. Let's see. Yeah, not one tear. It's super ugly crying type faces and stuff, but didn't actually shed a tear. There were no actual tears coming. It's really sad. Not for her necessarily, but for the children. Yeah, she said she was trying to protect her kids by blaming the 2-year-old. And she said that, and blaming the other people. Like the random black guy, and then her, and then Destiny's biological father, and she's blaming everybody to protect her kid. I was trying to protect my kids. That's what she was doing. That's what she was doing. Can I open up my window? Heck no, I can't. It's 80-something degrees out there. It's way too hot to open my windows. Way too hot. I don't get to open my windows during the day anymore once April comes. Really, once March comes most of the time. Keep the chatter. I never went to bed when you posted last night. I cleaned house. I finished working at, what time was that? 2 o'clock or something? And I set up, Jen Devka, it's all Jen Devka's fault, really. I was about to go to bed. I just finished working on stuff. And then Jen Devka had a thing on Twitter that was like how she stresses out if I don't have the stream made. And I was like, dang it, Jen Devka. So then I had to make it. And then I realized that for whatever reason, I guess because I was too tired, it defaulted to the time that I set it instead of like the time that I scheduled it instead of the time that I was scheduling it for. So, and then I realized like what it said, and then I was like, oh gosh, I guess I got to get out of bed. And I didn't realize this until I finally crawled into bed. I was like, I guess I got to get up and fix the time. But I did it. We did it. While I was on my portal changing to green, I totally mooned Lori Dumbbell. Ugh. Lori Dumbbell. Oh, we're going to watch that too. There was that hearing that, I don't know. I'm so tired. I'm so tired. That hearing that they had yesterday was really spicy. Remember we talked about the it was like Easter Sunday, and it was like midnight or something, and remember like the attorney like put in a motion saying that he was representing Chad Daybell, and we were like, okay, well maybe he was like, you know, like celebrating the holy day by taking shots or something. I don't know. It was almost like a drunk, you know, like drunk email type thing. And anyway, so that was what the hearing was about yesterday. And so we're going to watch it when Robin's sentencing is done. Yeah. David, yeah, the judge pretty much called the guy a drunk. So we're going to watch that when Robin's stuff is over. We'll watch that, and then by that time, oh, Ari posted it? Oh, I didn't know that. Well, we're gonna watch it anyway. We'll watch it anyway. Never seen Judge Boyd so spicy. It's kind of hot, actually. So funny. It's crazy, right? So much stuff going on. Why is Brandi so tired? Because I just don't get enough sleep. I'm just so tired. But let me show you something. Let me show you. Show you some of the. I have so many documents open on my. I spend a lot of time how many 1 2 3 4 5 6 7 8 9 10 11 12 13 14 15 16 I have 16 documents open. If that tells you anything about how I live my life, I have 16 documents open on my computer. And the reason for that is because when I'm working on stuff, I like to have everything that I can open so I can go back and forth and double check stuff before I post anything or before I record anything. And so I have all these things open. That's how my brain works. Member for 1 whole month, Betsy G, new to the fam. I found the place to put my slippers. Yay! Yay! Happy 1 month anniversary. I love that you put your slippers here. That's awesome. Love it when we have new members of the family. Love it, love it. No, Missy Russell, nothing else. And It's just lack of sleep. That's all. That's okay. I plan on trying to catch up a little bit this weekend, hopefully. We're going to do a short day today. I've got a lot of work I need to get done today. Oh, that's what I was about to do. I was about to show you. Let me exit out of some of this stuff. I can reopen it all when I start working on it again when we finish. But let me show you. I'm very excited about this. Very, very excited. All right, let's see. Okay. This is, dang it. I did it again. It did it again. It does that to, oops. Not that. I don't know why it defaults to that every time I have to restart my computer. Okay, so you can see that this is why I am excited, and it's worth the lack of sleep. If you can see, number 32 in the U.S. Woohoo! Yay! It makes me really happy. It makes me... Yeah, he had a bunch of misspellings, yeah. So, this is... This is exciting, right? It's cool. It's exciting. I'm excited about it. It makes it... makes it worth the lack of sleep. I'm really proud of that. 13th in the U.S. in true crime. And then I also had, let's see, I was in the top 150 for all genres, which is cool. I was number 148 in the United States for all genres, which is pretty huge. I mean, both of those are really huge. I'm excited about it, and I'm not going to feel bad for saying that. I'm not going to feel bad for saying that I'm proud and that I'm excited. It's a big accomplishment. It makes me happy. It makes me happy. Y'all's support has meant a lot. I appreciate it. It is pretty dang cool, isn't it? I think so too. So it's been a lot of stuff happening. Like we have, the podcast is doing well. We're almost to 20K. I think we're at like 19,200 and something. So we're getting close to 20K. Maybe we'll do like a fun 20K stream, just a short something to, it's always good to celebrate the good stuff, the fun stuff. Acknowledge the growth our little family has had. Good morning, y'all. Come on in. We're waiting on Robin Howington to start. I had to go run some errands this morning. Woke up early, had to go to the post office and go do a few things. And so when I saw that on the charts this morning, I was like, I'm rewarding myself. My reward for myself was McDonald's hash browns. I don't know what, and a McDonald's Diet Coke. I will tell you, you cannot convince me that there's something different about McDonald's Diet Coke than like just regular Diet Coke. It's different there from everywhere else in the world. it's like there's something, they do something to it. I don't know what they do to it, but man, it's so good. It's so good. Who needs a bingo win when you have that? Exactly. Kim, thank you so much. Just followed your podcast, new to podcast. Thank you so much. Thank you. I'm proud of it. 20K party! Woo woo! I'm excited. I sat here working on stuff for a long time yesterday, and then I saw that Bob was live. I've had Defense Diaries podcast on here before, Bob. And I saw he was live doing and publicly buzzed, doing a joint stream talking about the Karen Reed trial. So I jumped on over there. And then someone sent me a link for... Oh gosh, I forget the channel. I'll have to look it up. Sent me a link for another. Oh gosh, Phoenix, are you in here? Phoenix was in there last night, and can tell you what it was. I can't remember the name. Y'all know how my memory is, especially when I'm tired. It's delivered in bulk, not box bibs. Think a water heater filled with Coke syrup. I knew there was something different. I knew it. Their carbonation to syrup ratio in a canister that's different. See, I knew it. It's so good. Anytime like I'm out and about in the mornings, like if I'm running errands or something, I'm like, ooh, McDonald's hash browns and a Diet Coke would be amazing. I did get a coffee too, but you can't go to McDonald's and not get a Diet Coke, or I can't. It's like the best. Good morning. Yes, they showed it. I tweeted it. It was the link. It's just, oh, they're live. Just a small clip of, I'm like, I've moved everything because of, where is feature? There we go. Make it a little bit bigger. Mine's just a small clip on there, but she had, and then they did we watched a little bit of it yesterday, but I think as the trial goes on, she had said something about me coming on and like doing, like giving thoughts and commentary or whatever on the trial as it goes. So we'll see. Hey bros. Hey, I was just saying, Tiff Knox, I was just saying, I went to watch Bob on Defense Diaries last night do a show on Karen Reed, intro to Karen Reed. Remember their fried apple pies? Oh my gosh, yes, so good. Did you see their new toys for the adult meals? No, and I don't know if I want to. What kind of adult toys? Never mind, don't answer that. Scratch that, forget that. How did my scan come back? I'm thinking of you. Hope all is well and clear. I have been postponing it, honestly. I know that's bad. Oh gosh, if Calypson's in here, she's gonna fuss at me because I told her last week I would get it scheduled. I have not. I've been avoiding it. I need to schedule it. I canceled the one I had, and anyway, I need to schedule it. Anybody who's gone through it knows it's just so much easier to avoid it a little bit. Sometimes that's easier than knowing. Let's see. Had to give it McDonald's for my keto diet. It's like a treat thing for me. It's like an every once in a while thing for me. Remember they used to have those shaker salads? I loved those. I still get like this. I still do that to my salads. Sometimes I go get them and I'll do the shaker thing. I understand skins. Yeah. It's a real thing. It's so stupid. Get emotional even talking about it. Yeah, it's sometimes it's so stupid. Sometimes it's just, it gives a little bit of peace to just push it out a little bit so that you can, just have a few extra weeks of peace just in case, It's I think it's one of those things that, like, if you haven't been through it, it's a hard thing to understand about how it's just lack of sleep. About how scary it is, So it's just lack of sleep. Yeah. I think health is one of those things that you just take for granted until you don't have it anymore, So then it's like those the not knowing it's like and that's what I like try to explain to people who, like, all my friends who are like fussing at me about postponing it. Like, it's a little bit, it's just like you just want those few extra weeks of not knowing. And it's probably fine. I haven't been I haven't been sick like I was, like I was sick for months and, was tired all the time. So, I mean, it's more than likely like fine, but it's just that, I can't even believe I'm talking about this. It doesn't, it's, maybe planning to get a Diet Coke and hash browns afterward. That's the thing. That's the trick to get me. You can get me to go almost anywhere if you just promise me Diet Coke and hash browns from McDonald's. Oh, Danielle, I'm sorry to hear about your dad and your mom. I'm sorry. Miss Sassy Pants, thank you so much. Thank you, thank you. I'll set it. The Karen Reed trial is going to be half days on Tuesdays and Thursdays, so I can set it on one of those days. I've been putting it off long enough. I know I need to do it. It's just, I think after treatment ended, I just wanted to have a few weeks where I felt like a normal, I just wanted to be like normal for a little bit before I have to deal with it. It's all good. It's all good. Is this Karen Reed? No, Karen Reed is off today. So they're not doing the jury pool stuff on Fridays. So this is the sentencing for Robin Howington. Not Howard. I don't know where I got Howard. The sentencing for Robin Howington, which is a trial we watched. Well, how long has that been? Maybe a month or so ago. I don't even know. Everything runs together. I know y'all would all go with me. It's weird when I go, I don't like anybody going with me. I think that it becomes this and I know any of y'all who have gone through major health issues probably know and understand it, but it almost becomes like this thing, like where you feel like an obligation to comfort other people about what you're going through. So you can't really, you don't get a chance to process things yourself because you're comforting other people and trying to make them feel better about what you're feeling or what you're going through. So I've always, I got used to going through all of this stuff alone because it's just easier that way. When I went through my like chemo and stuff, like when I was doing all of that, after I was diagnosed, I went through it during COVID. So I couldn't have anybody there anyway. So I was in the hospital for most of 6 months, I think. And couldn't have visitors and stuff like for the majority of it. And I think I got used to that. And then when I did have visitors, it was always like when during COVID, y'all know how it was, like things changed like on a daily basis. And so when I was able to have visitors, then it was like it was people like, my piece of crap husband at the time came every once in a while, but and I had like my best friend that would come. Well, anyway, the people that would come, I spent most of my time, because they hadn't seen me, I spent most of my time comforting them about it. You know what I mean? So I think that for me, it's always been easier to do it by myself, because then I can process it without having to. Yeah, exactly. Ashley, you have to, like, you feel like you have to be strong for other people. Even when you feel like you're like breaking down, you feel like you have to be like, it's okay, I'm going to be fine. I'm, whatever. So I think that it's like that, that instinct to make everybody else feel better about what you're going through keeps you from being able to process it and feel it yourself. Like when I had that last scan where she said that there was something new on there, I wasn't as worried as I was the first time, because she said like it hadn't formed into nodules or whatever, and it wasn't, it was I was obviously like in a lot better situation than, like, because I'm having to do the scan so often, like I was in a lot better situation. It's, caught early. So it wasn't even like as scary as it was the first time, but I think it was still like, you go through that stuff where like you haven't really processed it. And then when I had my friends in from out of town, because this is right around the holidays, when I had my friends in from out of town, it was like the first that I was able to, like, after they left, I should say, like when they were here, it's like you kind of push it all down and, everything's fine. It wasn't until like they left, I'm like by myself again, that I'm like, then you're able to process it, which is a weird thing, isn't it? Like to feel obligated to make everybody else feel better about the stuff you're going through. It's a weird thing. It's a process. The whole processing of all of it. Because a lot of times it feels like, it's like you're kind of like you're on the outside of it, If that makes sense. Like this is something that happens to other people. This is something that you send thoughts and prayers about. This is not something that like happens to you. So it's like a weird process to go through, understanding that like, oh, this is something I'm dealing with. It's a weird thing. I didn't talk about it a lot until like the first few times I talked about it, and like I had so many people reach out to me like, I'm so glad you said this, I'm so glad so I try to be really open about it, but because I know that so many of us have gone through health issues, or of course all of us, I'm sure, love somebody who has, if we haven't gone through it ourselves. So I try to be open about it. Yeah. You haven't processed it yourself, and in the moment you're focused on what's happening in that moment instead of allowing your brain to function rationally and process. Yeah. It's such a weird thing. Hello, the glare. Hello. Welcome. The glare, we're getting ready to watch, if they ever start, Robin Howington's sentencing. If it ever starts. The glare has been covering Karen Reed in depth as well. Actually, that's why I was late the other day. I was in Glare's chat and then was like 10 minutes late to my own show. So I got caught up laughing. But we've known each other before. We started following each other before Karen Reed, the Glare, and I. When did we start? I don't even remember when we started following each other. I know it was before Karen Reed stuff, though, wasn't it? I'm pretty sure it was. Because you had watched stuff in here before we covered that. And I'd watched some of your stuff before we covered that. And then somehow we got lost in the Karen Reed circus together. Circus. Oh, the circus. It has become kind of a circus. Betsy G said, I don't know why I'm tearing up. Me neither. I tell you what, that's what, by the time I get to Friday, I'm so tired. Everything makes me more emotional. That's what I'll blame it on. They did not choose the rest of the jury yesterday. They did seat one more. So there are 12 seated now, and they need 4 more so that they can have the alternates. So, getting close. Getting close. I think that if they are able to... if they are able to seat the other 4 on Monday, then maybe we could have openings by Wednesday. And then we really will live here. We really will. Oh, that reminds me. On Monday, we are going to do a big air conditioner again. Can't do anything about it. Florida's hot, y'all. We are going to do a big Karen Reed review. We're going to go over timeline, details, who's who, kind of an intro to the case, and then we're going to watch the hearings from before together and just do like a big crash course getting ready for all of it, because this is going to be a big trial. You know, there are a lot of people who are just now hearing about it or just now realizing how crazy this is going to be, and so they're kind of trying to figure out, you know, what's going on. I do plan, Robin's Crime Files, welcome. Become a member. Oh, hair's falling out. Welcome. Sunshine State of Mind, I am going to be covering Chad Dorman. His actual trial is starting in July. Ow. So, Karen Reed should be over by then, unless this is going to turn into like, how long was OJ's trial? Like 9 months or something. I don't know how long it was. It feels like forever. Unless it turns into one of those, which it very well might. It should be over by then. So I will be covering that one. That one's going to be really tough. It's going to be really tough, but I am going to be covering that one. There's, for the hearings, I will be showing those. If they are at the same time as Karen Reed, it will probably be one of those things where we, show it after, because everything that we do for Karen Reed is going to be live. But I will be covering it. It's going to be a hard one, though. I'll tell you, it's going to be a hard one. And I will probably have to mute my mic a lot, because I will probably be cussing him out a lot. Like a lot. Are you going to cover the mom of Boy in the Box case with Mark Shiner? It depends on scheduling. I'm going to try to cover all the ones that we have covered on here and talked about a lot on here. I will try. I love Mark so much. Will you go down the witness list? A lot of names I don't know. Yeah, we'll try to do that Monday too. If not, if we can't get to it on Monday, we can do it on Tuesday. But I plan on the beginning of next week. Monday's going to be like a big Karen Reed crash course thing, and then it will probably carry over into Tuesday. So depending on scheduling, kind of play it by ear. But yeah, we can go over that too. It'll be like cramming before exams. Yeah, I'm going to have flashcards and everything. Like, who's this person? Who's this person? When does that one start? Let me pull up my handy dandy calendar, y'all. Let's see here. Where's Robin? She's late. 45 minutes late. I tell you what, I'm taking a little break, hopefully. Next week we have Courtney Clenny hearing, too, on Tuesday. There's a Lori Vallow hearing on the 24th, I think, but look, their docket's so messed up. I don't even know what's going on with her. Kent Mahini has a hearing May 15th, too. I'll be interested to see that. Beverly McCallum's sentencing is next month. Erica 843, member for 8 whole months. Woo, woo. 8 whole months. Happy anniversary. Happy anniversary. Let's see. Michelle Draconis' sentencing is May 31st. William Mozingo is June 10th. Lindsay Shiver, July 1st. Chad Dorman, July 8th. Tracy Ferreter, July 12th. So Chad Dorman is probably going to go into Tracy Ferreter, so I may not be able to cover both. Might have to do a highlights thing. August 1st is right now what I have Vallow down for. And then, of course, September. I mentioned this yesterday or the day before or sometime in the recent history. I don't know, days run together. So as of now, because y'all know how this story goes and things can change. As of now, September 9th is when jury selection is set to start for Laurie Shaver. 1 week later is when it starts for Donna Adelson. So I had thought about I was planning originally on going to Donna Adelson's trial because it was scheduled for later in the month and Laurie's would have been over by then. But with it being now moved up, I don't think I can do both. So I'm going to kind of figure this out, and I'm not making any big decisions right now because, of course, y'all know how it goes. Things change. But if it comes down to choosing between the two, I will more than likely go to Laurie Shaver's trial because I know that there will still be coverage of Donna Adelson. Other people will be covering it, but I have not seen anybody else covering Laurie's. And that might be because there hasn't been like a ton of attention on it yet. When it gets closer, I'm going to do a video going through all the details because it's so freaking crazy. And I have interviewed I have talked to my friend about doing an interview with her. She's a little bit apprehensive because right now Laurie's still out on bail. Like, she's a free woman. We know a lot of the stuff that's going to come out in Donna's trial. This is not our first rodeo with Donna, so we of course want to see that one. We want to, watch justice happen. But at the same time, we do know so much already about that one and what's going to come out, because we've seen, the previous trials. We saw, obviously I was at Charlie's trial, and then, we watched here on the channel, when we were getting ready for Charlie's trial, we watched the previous trials for the other co-defendants. So that, to me, it'll probably be me going to Laurie's trial. Also, I need to put in a media request and find out if there's going to be any video coverage there. Yeah, Laurie Shaver is the one that my college roommates became friends with, and they roasted marshmallows over her husband's dead body and didn't know it. That's the one. She has been out on bail, and she finally goes to trial. They've finally got a trial date set for September 9th. And the victim's family are kind of over her BS and don't believe that, that's not what I mean. I mean, they're not fully confident that it's going to happen, because she's gotten out of this so often. But we'll see. If there's not already, because right now there's nothing on the docket showing that there's been any kind of media request to cover it. So if not, maybe I should talk to RA and maybe get him to, with his media company, tell him, record it, stream it. The Laurie Shaver trial it's going to be wild. It's crazy. She, for those of you who haven't followed, Chad Dorman is July 8th. So yes, I'll plan on covering that one. The Laurie Shaver trial, so it's going to be wild. And okay, so here's the thing. There's so much to it, and I'll do a video when we get a little bit closer, to kind of go over some of the details. But her husband, just like Cliff's Notes version, her husband went missing, and she said he left her and took off, and they have a child together. And depending on who asked her and on what day, it was always a different, there were different stories about where he was. It was, he took off and went to Iraq or something, or Afghanistan or something. He took off to New York, he went to California, he went to Georgia. There's all these different places that he supposedly went. But his family hadn't heard of him. He ended up, his job got a text from him saying, a few days after he went missing, got a text from his phone saying, he quits, he's not coming back. When people would look for him, his phone would say, would send text messages saying, I'm leaving, don't look for me. She was having an affair with a married man and got his name tattooed in her in spots where she doesn't have to put sunscreen. And she thought that it was a lot more serious than he did. I think to him it was just more all about sharing those moments where you're sharing the parts that you don't put sunscreen on. And so when she thought that they were going to like be together forever and he was going to leave his wife and stuff, and she realized that that wasn't happening, then she pretended to be her now missing husband, and on his Facebook, and reached out, pretending to be her missing husband, reached out to the guy that she was having the affair with, reached out to his wife and said, like, hey, my wife and your husband are having an affair, because she was trying to get him busted so that the wife would leave him, since he wasn't going to leave her, allegedly. And they have all this, I mean, it is wild when you follow like, even sent flowers, to, yeah, it was all about the whoopee. That's a much nicer way of saying it. I was trying to think of a you know, classy way to say it. Non-marital congress. That's better. But yeah, so she like sent flowers, you know, like pretending to be, I mean, it's kind of like a little bit like creepy, the links that she allegedly went to. But then so that didn't work out. She ended up getting into another relationship, and they got married somehow, even though she was already married and her husband was missing. Oh, and she used his cards and like got loans in his name and stuff right after he went missing. And yeah, she got a tattoo on the bottom of her foot. That's what I meant by the places you don't put sunscreen. Yep, that's exactly what I meant. But she got loans in his name and stuff, and like, I think used his card, if I remember right. I have to go back over the notes, but I think she used his card like within the first few days or something. But you know, of course, they're able to track all this stuff, and so then she gets into a relationship with a new dude, and new dude ends up helping her build a new fire pit in her backyard. And the new fire pit is concealing the body of her missing husband. So my college roommates, their kids went to school together, so they went over there. You know, me and my friends, like, we're all into, like, we're like riding four-wheelers and going mudding and shooting and all that kind of stuff. That's kind of like how we grew up. That's, you know, and so she does a lot of that stuff too, and they have like property and stuff. So like they would go over there and like ride four-wheelers and stuff and like, you know, do things. And they had this brand new big old fancy fire pit. And my friend said that they went over there and like were roasting marshmallows and stuff. The kids were, you know, roasting marshmallows on this new fire pit. And then turns out they come and arrest her because the body of her missing husband is buried underneath this fire pit. And when they arrested her, she said that she tried to have her defense tried to have it to where her 7-year-old daughter confessed to shooting her dad in the head, and so she wanted to have it all pinned on or she wanted to let her 7-year-old daughter, well, it was 7 at the time, take the blame for it. Crazy. And there's other stuff too. I mean, like they had separated for a while. Things got real toxic. They had separated for a while. He started dating another woman when they were separated. And now keep in mind, she's already like moved on and stuff. So he started dating somebody else, and then all hell broke loose. There's a lot to it. I'll do a video on it, like with all the information before the trial starts, but it's a wild one. It is a wild one. So I will be covering that one in September. Plus, since I have a personal connection to it and nobody else is covering it, I like doing stuff that nobody else is covering. Julie Frazier, member for 6 whole months, maybe a smidge longer as part of the fam. Happy anniversary. Happy anniversary. And where'd it go? I just saw Nancy D. There it is. Nancy D, member for 9 whole months. I am definitely living here. Love you all. Nancy D, we love you too. Happy anniversary. Happy anniversary. How did they find out he was in the fire pit? Let me just pull it up. Let's pull up. I think there's been a couple of articles about her. Look, I'm like savoring this dang McDonald's Diet Coke. All right, let's see. Florida woman. It's always Florida man or Florida woman, isn't it? Giving us a bad name down here. Let's see. Oh, Erin Morgan. Remember for 11 whole months. I swear it's been a year, but I think the first month was a gift. Love it here. Love you, Brandi, and love our chat. I love you too, Erin Morgan. Happy anniversary. Happy anniversary. We haven't had the first 1 year yet. We're getting really close. It's been, because they took forever to approve my monetization stuff so that I could have members. So I've had the channel for over a year, but it took like 3 times as long for me as it did for every other person I talked to. It was crazy. So, but hopefully, hopefully it's coming up. You're right up there. 11 months, y'all. We're getting close to our first 12-monther. Erin Morgan's been here since right at the beginning. I love that. Adulting has me missing more of the stream than when YouTube kicks me out. Ugh, it does that so much. Drives me nuts. Regina Crawford, good to the membership. Thank you so much. I went to Rosebud. Rosebud, you look good in green. Regina Crawford, thank you so much. Thank you. Thank you. And Mary M. Oops, where'd it go? Brady, you and your mods in chat that keep me coming back. Thank you, Mary M. Happy 6-month anniversary. Happy 6 months. Happy 6 months. Every time I hear Florida woman, I call my daughter. It's all, that's how we do it down here. We all wild. It's all right. It's the sun. It gets to us. All right. A Florida woman accused of murdering her husband and burying his body under a fire pit in their yard in 2015 now says, this is from last year, now says a 7-year-old girl fatally shot him and is willing to testify on her behalf. So not only is she saying that her 7-year-old daughter did it, but she said she'll testify to it. In September 2020, Laurie Shaver, 40, of Claremont, was charged with second-degree murder, domestic violence, and accessory after the fact in connection with the 2015 disappearance and death of her husband, 33-year-old Michael. It says Shaver, according to the Lake County Sheriff's Office. In February 2018, a friend asked police to check. Oh, the curtain's moving, or flag is moving. In February 2018, a friend asked police to check on Michael, a monorail technician at Disney World Resort in Orlando, who was last seen in November of 2015. Authorities said Michael would never leave his family, court records show. Virginia, I've been here since Travis. I think it's been here. Happy 8-month anniversary. Happy 8 month. Happy 8 month. She should be put in jail just for blaming her daughter, right? Isn't that awful? It's awful. Little B, get to 5 memberships. Thank you so much, Little B. Welcome to our new members. Welcome. Y'all look good in green. Yeah, imagine learning where you were roasting marshmallows. That's crazy, isn't it? It's crazy. Okay, so let's see. February 2018. Oh, we have audio. That means they're coming. Angelina Knox, member for 9 whole months. Hi, Brandi. Thank you for making a great home for us all. Thank you for being here. I'm glad you're home. Rent's due. Just joking. Happy anniversary. Despicable, blame your kid. Isn't that awful? 7 years old. 7 years old. And she's like, oh, she'll testify that she did it. All right, let's see. So on March 9th, 2018, investigators had a search warrant found Michael's body buried underneath a concrete slab in a fire pit that Laurie allegedly placed there to cover up the burial spot on the couple's 5-acre property. She has pleaded not guilty and is out on a $50,000 bond awaiting trial in September. Now, nearly 3 years after Laurie's arrest, her lawyer filed a motion in court claiming that a 7-year-old girl who is now 14 is the one who actually pulled the trigger. This is her and this is him, obviously. On May 8th, defense attorney Jeffrey Wiggs filed a motion asking the 5th Judicial Circuit Court to reconsider its May 4th request to evaluate a minor child who confessed to having committed the respective murder in this matter. So she's saying that her daughter has confessed to shooting him in the head, and she wants her to get on the stand and testify to that. The minor child has been apprised of, I'm eating my hair, of the rights that she would be waiving and the possibility of penalties that she would be facing. 7 years old. Nonetheless, the child has persisted in seeking to testify. He adds that these facts were mentioned by the attorney representing the minor child. The Lake County prosecutor said in an email that no credible evidence supporting the claims made concerning the involvement of the child exists, and that the child has not made statements to any law enforcement agency. So that's a big thing. This child has not said any of this to any law enforcement. Only the attorneys that... Jesus. Lord help me. Wiggs claims the prosecutor is wrong. Here, the state has sought to bury their heads on what evidence which may truly seek out and ensure justice is obtained. Family members and people that are close to them have said that this has been a long process of like alienating her daughter from her father, and like really kind of trying to drive that wedge and planting information. This is what their friends and family have told me. So I think that's really sad. Could you, like, I mean, that's, one of them told me that she believes that that the mom has actually convinced her daughter that she did it. I don't know. It's really sad. During their marriage, Michael and Lori were known to argue frequently and had split up before. The high school sweethearts were allegedly known to threaten each other with guns, court records show. After Michael disappeared, Lori allegedly posed as her husband on Facebook Messenger to make his family and friends think that he was alive. The mother of 4 began dating another man, the father of her 2 youngest children, after Michael vanished. She married her boyfriend, Travis Filmer, in 2016. Oh, thank you, Nikki. Thank you, Nikki. Rent wave. Love you all. Brandi, you're the bee's knees. Thank you so much. Thank you. Thank you. I appreciate it. Thank you. Thank you. Rent wave. Y'all crack me up. Oh, okay. So she married Travis in 2016, but keep in mind her husband was missing, allegedly. So, how you just go marry somebody else? In 2018, deputies from the sheriff's office showed up at her property asking to talk to Michael, who had been reported missing. Lori told them that her husband had abandoned his family, according to an affidavit from the Lake County Sheriff's Office obtained by People. She let them inside the house to look around, but when deputies asked if they could bring in dogs to search the property, Lori allegedly told them to come back with a warrant. On March 9, 2018, police returned with a warrant, cadaver dogs, and ground-penetrating radar. By the end of the day, they found Michael's body buried 3 feet under a concrete fire pit in the backyard, wrapped in a fitted sheet that was wrapped in a tarp and secured with straps. An autopsy showed that he had been shot once in the back of the head with a .38 caliber handgun several months to several years before. I'm still in shock, Wilma Nicholas, the shaver's next-door neighbor, told People previously. There's moments where I just can't believe that the guy is really gone. Lori has maintained her innocence from the start. I would never cause any harm to the father of my children, she explained in a March 2020 YouTube video. That video is interesting. We'll watch it. We'll watch it if it's still out there. Seeking donations for her impending defense. So she did this YouTube video asking for money for her defense and saying that she is innocent. She maintains her innocence. And she is innocent unless proven guilty. But I ain't donating to that. Natalie, subsidized rent wave. Thank you so much, Natalie. Thank you. Thank you for super chat. Thank you. Hi, Advocate. Hello. Some of y'all snuck in while I was reading. Hello, welcome. Let's see. I know that there's people out there that are trying to paint this picture of me, but that's not me. I'm loving, I'm caring, I have a servitude heart, I don't judge people, I accept all, and I always try to see the good in everybody. The prosecutor in wigs did not immediately respond to people's requests for comment. So I am not allowed to reveal certain things yet about like certain conversations around the fire pit drinking beer. But I will tell you that when I get ready to make this video and when my friends, when we get a little bit closer and my friends I interview them, like, instead of just talking on the phone and stuff, like when I actually interview them and record it, y'all are going to be, it's a wild one. So, and the reason that I feel like I'm going to cover this one instead is because obviously part of it is just the fact that, you know, it's like, you know, my friends of decades have a personal connection to her and didn't know. And nobody else, you know, this one doesn't have a lot of attention. So, does my friend believe that she will have to be there to testify? Not sure yet. She's not sure yet. But if she doesn't, then I'm going to stay with her when I go for the trial, because obviously it's in the same town. So when I went to CrimeCon in Orlando, I stayed with them. Laura just sent a Venmo. Thank you so much, Laura. Thank you. Thank you. Thank you. Thank you. I appreciate it. I wish there was a way for me to show those on here, but there's not. Laura says, congratulations on 19K and great rankings. Yay! Thank you so much. Thank you. Thank you. Thank you. Thank you. It's exciting. Book Bug for Life. The trial I was talking about is Laurie Shaver. It's going to be in, right now it's scheduled for September. We'll see if she weasels her way out of it, like she has with other court dates. I mean, it's been, right now, you know, keep in mind, like, she's out on bail, so she's totally fine. Pushing it off as long as she can. They live in the same town, and their kids went to school together. Hello, hello. I don't know what's taking so long. What are they, like an hour and... almost an hour and a half late. When you start to cover the Karen Reed case, your channel is going to explode. You know, I thought, I figured, like, you know, I figured it's going to be a big case. It has gotten, like, since all this crazy stuff has been happening in the last, you know, little bit, it's gotten bigger and bigger, but now so many people are covering it, so we'll see. It's interesting, though, because there's a lot of people who don't know anything about it that are jumping in and covering it now. And I can't imagine, like, it's such a complicated one. I can't imagine coming in right before it starts and trying to figure out all the craziness from it and trying to keep that situated. But I mean, that's what the jury's going to have to do. So I guess, like, if you're covering it as a juror, then that's, you know, different than like doing the deep dives, because y'all know how we do here. Like some of them will go into it as like the deep dives, like the Thami and the obviously Karen Reed. It's like the deepest of the deep dives. But some of these will go into with, you know, a lot of research and background and time invested before we get into the trial. And then some of them we go into with bare minimum information and watch it like from a juror's perspective. And I love those too. I love both of them for different reasons. Like Travis, we did Travis going into it as a juror. We didn't do any kind of background on it or anything. And actually I went into it thinking like just what we had heard from the prosecution. And I thought, well, like, that doesn't sound like self-defense. He's going to be guilty. Obviously, you're always, you know, open going in, but it's instinct to lean one way or the other based on just what you hear. And then once it came out and it was like, oh, so they're not actually telling us the truth about everything that happened. Prosecution's not. And by the end of that, by the end of that trial, we were all like, "Free Travis!"
All right, we're ready to get started on Miss Howington.
Finally.
Bring out Miss Howington. Let me see her file, please. Miss Howington, have a city council table, please. All right, let's go through Ms. Howington was convicted in docket number 117659 in count 1 of the lesser included offense of reckless homicide. It's a Class D felony. Does everyone agree she is a range 1 offender?
Yes, Your Honor.
Judge, I did file a sentencing memorandum, which I argue especially mitigated.
I understand, but I mean, she doesn't have any range enhancement convictions.
Mike, I didn't get a copy of that. I apologize. I don't have a copy of Mr. Whalen's sentencing memorandum. Is there a way that I can get a copy from the court's file? I think it was filed yesterday.
You can have my copy. I've already read it. Yeah, go burn it. All right, so she's 2 to 4 unless the court were to find she's an especially mitigated offender. In counts 2 and 3, she was charged and convicted of aggravated child neglect, a felony. Which count was the serious bodily injury count? Which count was the weapon count?
I believe 2 was the serious bodily injury, 3 was the weapon.
All right, so she's 15 to 25 on each of those unless the court were to find she was an especially mitigated offender. Where are the other notations? She was found guilty in count 5, tampering with evidence, a C felony, 3 to 6. Count 6, attempted tampering with evidence. D, felony. Thank you.
I forgot I'm muted. I forgot how much I like this judge.
D, felony. 2 to 4. Was there not a false report conviction as well? Yes, count 4 is false report. D, felony. 2 to 4. All right. Does either side have, other than victim impact, additional testimony that the state or Ms. Howington wishes for the court to consider before the imposition of judgment in this case?
Your Honor, no testimony from the state. I would like to introduce the PSI as Exhibit 1.
All right, mark the pre-sentence investigation report as Exhibit 1.
And then, Your Honor, Antoine Oliver has provided me with a few pictures of the victim that he would just also like the court to see before she died.
I mark those collectively as Exhibit 2. Mr. Whalen, any exhibits?
No, Your Honor.
All right, let me hear the state's position. Let's start first with enhancement factors the state believes are applicable to each of the various counts of conviction.
Yes, Your Honor. So the first one that we would ask the court to consider is that the defendant has a history of criminal convictions or criminal behavior. As noted,
Assuming you're urging that that applies to each of the 6 counts. Counts 2 and 3 merge. Which count is, I'm assuming the state is asking count 2 to be the one that stands, correct?
yes, Your Honor.
All right. So, previous history of criminal convictions or behavior.
Yes, Your Honor.
All right, what's the next one?
That the victim of the offense was particularly vulnerable because of age. I think that probably only applies to count 1, being the reckless homicide.
What is the statutory subpart number for that?
That is 4.
Okay.
And then 6, that the personal injuries inflicted upon the victim were particularly great. I believe that would only apply to count 3. That would be the use of the deadly weapon.
Okay.
Factor 8, that the defendant before trial or sentencing failed to comply with the conditions of a sentence involving release into the community. And then 9, the defendant possessed or employed a firearm or other deadly weapon during the commission of the offense. That would only apply to 1, 2, and 5 also, because that was the tampering that involved the weapon, but especially to 1 and 2. It wouldn't apply to 3 with the deadly weapon.
So which tampering count was the weapon?
That was count 5, that she was actually... That was the full tampering, and then count 6 was the attempted tampering of the phone.
Okay.
And then finally, factor 10, that the defendant had no hesitation to committing a crime where the risk of human life was high.
So could you clarify? I think what the court said was counts 2 and 3 merged. So we're now talking about applying.
I have to enter separate judgments of conviction on each, but by operation of law, those judgments will merge. But they can argue the enhancement factors that they believe are applicable as to each count.
I just love his voice.
3 merging into 2 is that?
3 will merge into 2. All right, General, do you wish to be heard on any of the enhancement factors? Do you have any argument?
Yes, Your Honor. I did file a sentencing memorandum, so I won't go through them as extensively as I did in the sentencing memorandum. But just as it relates to that first factor, the previous history of criminal convictions or behavior, the defendant does have a couple of prior misdemeanor convictions, it looks like, for failure to appear, driving on revoked, and a DUI. But really what I believe is most applicable here is the criminal behavior. We heard during the trial that the defendant was engaged in drug transactions prior to this, prior to the shooting of her daughter. She was selling pills to people. Mr. Key testified about that. He further testified that he actually met the defendant because she was selling pills to another individual that he knew. She, in her own interview, admitted to selling drugs. That was apparently her, that is why she claims she tried to destroy her phone, is because there were evidence of drug transactions within her phone. But not only that, Your Honor, I want the court to take notice of all of the other things that she did in this case in particular that she wasn't charged with, okay? And so specifically, again, if we're believing Ms. Howington's story that it was her 2-year-old that got the gun and shot the 5-year-old, having the gun where the 2-year-old could possess it in and of itself is neglectful. Obviously, she wasn't charged with that, but I do believe that it's something that the court can consider. Additionally, I think that it's very relevant that in this case, this defendant tried to literally frame the victim's father for first-degree murder. She went so far as to actually pick him out of a police photo lineup. That's how far she took it. I mean, by my count, she easily could have been charged with probably 10 or more reports of false reporting because she gave a different statement almost every time she opened her mouth. And so we would just ask the court to take notice of not only the criminal convictions that she has, but even the criminal behavior in this case alone that she wasn't charged with is very significant. As it relates to factor 4, that the victim was particularly vulnerable because of age, again, I believe that this applies to the homicide count. Here, the victim was 5 years old. Obviously, she was very vulnerable. She was very young. I mean, we heard the testimony. She was sitting on her couch watching cartoons when she was shot and killed. She actually had the remote in her hand. The bullet passed through her hand, passed through the remote, and went into her chest. And so we would ask the court to apply that particular enhancement factor to that count. The personal injuries inflicted upon the victim were particularly great. Again, this would only apply to count 3, the use of a deadly weapon. Obviously, we know that they were great. She lost her life. The defendant before trial or sentencing failed to comply with the conditions of a sentence involving release into the community. The defendant was on bond for several years in this case. The pre-sentence investigation reports that are part of the court's records indicate that she failed multiple drug screens up until, I believe, the middle of 2022. So almost 2 years that she was on pretrial, she kept failing drug screens for marijuana. In the pre-sentence investigation report, she admits that she kept smoking marijuana until 2022. Which would be a violation of a pretrial release. Possessed or employed a firearm. Again, I know that her story was that the 2-year-old possessed the firearm, but at the end of the day, this was her gun. She admitted to that. If it is true that she just left it around the house, it's still her responsibility. Also, it applies, I believe, to the tampering count, where it specifically involves her trying to conceal this gun in the bush outside the home after her daughter was shot. And then finally, as to the last one, again, that the defendant had no hesitation about committing a crime or the risk of human life was high.
How do I apply that in this case?
So I believe that that would go to the child neglect in this case. I mean, she had no hesitation whatsoever. She knew she had a gun in her house. She claims that she knew that somebody else had apparently put it back in her house. She didn't try and check to see where it was. She didn't try to make sure that it was safe. She didn't attempt to make sure that her children couldn't gain access to it. She did absolutely nothing as it relates specifically to the neglect, knowing that...
Not subsumed by the elements of the offense on the neglect?
Well, I don't know that it's fully subsumed within them. I guess it could be potentially in the deadly weapon. I'm not sure that, I mean, serious bodily injury doesn't mean that somebody's going to die. So I don't know that it's all the way consumed within the serious bodily injury count. But again, like I said, this was her gun. She apparently didn't know where it was for days, but a 2-year-old finds it in about 4 minutes. So we would ask the court to apply that factor as well. Do you want me to, are you just focusing on the enhancement factors for now?
I'm just focusing on the enhancement factors. Mr. Whalen, address the enhancement factors as urged by the state, whether you agree with them or object to them. Once you have concluded doing that, address whatever mitigating factors you believe are applicable under TCA 40-35-113.
Yes, As to the history of convictions or behavior, there is the most minimum of misdemeanor history in this case. And on top of that, it was this failure to appear in Sullivan County where she was sentenced to do community service and gets raped by the officer who's managing the community service program 18 months before this incident, which, as I will argue later, contributed to the PTSD that she was suffering at the time this happened. And the abuse of Mr. Oliver, who apparently is not going to be standing here today saying anything either.
Your Honor, he is going to give victim impact statement. He's asked the state to read it, just to let the court know.
He has the right under the statute to give a victim impact statement.
I understand that. He will not be giving the victim impact statement. He'll have them read it. He didn't testify at trial, though some of what he said was used. So
focus on the enhancement and the mitigating factors.
That is one of what we'll also be arguing as mitigation. The state wants to talk about uncharged drug transactions. The court might recall Ms. Howington's interrogation and how many times Riddle told her, we ain't the drug police, we don't care about drug cases, this ain't about drugs, this is about a 5-year-old child who's dead. Then we introduce it at trial, now we argue it at sentencing, even though she wasn't charged. So I would suggest that none of that should apply, Judge. Rumors of conduct should not be used for sentencing purposes in a case like this or any other case. That there are constitutional guidelines for a reason in the plea agreement form, which is produced by the court, and in those cubby holes over there, it talks about, you understand that if you enter this plea, these charges could be used if you are convicted of something in the future. The idea of vulnerability of the child, that is one of the elements in the child neglect. So
I think they're only urging that as to count 1, the reckless homicide.
And I don't know how you use that in what the jury had an opportunity to convict her of, felony first-degree murder. Did not, and found reckless homicide. And so a reckless act is not something that should be considered when we talk about the age of the victim. What they said was, that the state said, no one's going to tell you that she intended to do this.
Well, what the case law says interpreting that particular factor is that there has to be the vulnerability of the victim has to be in some way causally connected. In other words, it was easier for the defendant to commit the crime because of the particular vulnerability of the victim, be it age or some form of infirmity.
And I would suggest that either under a negligence theory or reckless she was convicted of, there's nothing that would suggest this crime was committed in order to take advantage of the young age of the individual. So I don't think that applies, Judge. And again, injuries inflicted upon the victim were particularly great. Again, she was charged with felony first-degree murder, was not convicted of that. And so we're back to the reckless homicide and...
Well, death's an element of reckless homicide.
Right. And so I don't see...
But I think the argument is that the injuries as to count 2, the aggravated child neglect count, that the statute requires that they prove serious bodily injury. In this instance, it went beyond that. It was death.
Well, and what we have is a case in which count 1 was homicide, a felony murder in perpetration of aggravated child neglect. So when the jury finds finds her not guilty of that charge, finds her guilty of reckless homicide and aggravated child neglect, it puts you in a different situation because technically that's the definition of felony murder. So we're saying, okay, there was a reckless homicide and the underlying felony of the felony murder. And so I don't know how you separate those now at this point for sentence enhancement. And again, I think more so, not all cases are the same. This is a case where they're saying and said to the jury, we're not telling you she intended any of this to happen. And then, again, almost like with the age of the victim, if she didn't intend any of it to happen, then how do we hold her responsible anymore for particularly great injury that she didn't intend to happen than we did for age? This was a horrendous family tragedy, which has not been made any better for anybody because of this trial and its conclusion. It's still a tragedy, and it's as much a tragedy for Ms. Howington as it is for anybody else.
Unfortunately, Mr. Whalen, most of what this court deals with on a daily basis is tragedies.
I don't disagree, Judge, but we rarely see them at this level. I mean, in this circumstance. I don't know how pretrial release got to be a sentence of release to the community.
I'm not very concerned about that.
But I have to say, because the state has brought it out, if you look at the entire report, which is attached, I believe, to their memorandum, shows that she had 3 April, May, and June dirty drug screens, which for a regular user of marijuana would not necessarily be unaccounted. You would almost expect that to be true for 90 days. After that, she'd been clean every time they tested her. She did everything pretrial asked her to do, made every appointment, kept up with payments, kept up with payments for GPS. I would suggest she was very successful in that particular endeavor. So for those reasons, we don't believe that any of the enhancements should apply in this case.
What mitigating factors under the statute do you urge?
I would, number 3, that substantial grounds exist tending to excuse or justify the defendant's criminal conduct, though failing to establish a defense. And again, Ms. Howington, at this point, no one can deny that she was diagnosed and treated for PTSD based on the rape at the hands of a police officer in Sullivan County and the physical abuse and mental abuse and emotional abuse of Mr. Oliver, including 3 days before this event when he shows up and then wants to talk about how he's the victim of that. But she had to get a gun to say, get off my property. He wouldn't go away. He's upset because she's got her boyfriend there. So there's that. Then we have that she comes home after taking the kids across town to their favorite park, comes home in the dark, is at the house, a shot rings out, which, as you recall, during voir dire, we talked to lots of potential jurors who had people with PTSD in their life, who said that shot going off would be a trigger. Then saying that it's your daughter has been killed and your son has pulled the trigger. All those things contribute to the mental state she is in when she is then taken to the hospital, not allowed to go with her daughter, but taken to the hospital, told her daughter is dead, and within an hour is in the interview room with Mr. Riddle. And when she tells them she's nervous because she was raped by a cop, he loses his mind and yells and screams at her and questions her humanity. At that point, that interview was over. She is fully triggered at this point, and by an officer who's sitting there talking to the woman whose child is dead and yelling and screaming at her over and over again. And the state then stands up again and says, well, you should consider as an enhancement factor uncharged conduct in that she tried to frame Antoine Oliver. The testimony is crystal clear. I asked them, who raised Antoine Oliver as a suspect first? They did. Then you asked her, do you believe he would do that? And she said, no, I guarantee you he didn't do it. And then they stayed on it until she says, I can't take it. You're right. I can't take it anymore. You're right. She did not try to frame Antoine Oliver. They did. And then you have the nerve to come in here and tell the jury different and then stand up at sentencing and say different. That is not true. It has never been true. She agreed with them after denying it and telling them she guaranteed him he did not do it. A woman who, in her mental condition, is in the interview room from about 11 p.m. until 4 a.m. with them. She did not get the 48 to 72 hours a police officer would have gotten to be able to get their thoughts together.
This is not an officer-involved
shooting. She went from the hospital being told your daughter's dead to being interviewed.
Oh, God. This is not an officer-involved
Further, we
shooting.
would say that
She's not an
number
officer.
7 applies, that she was motivated by a desire to provide necessity for her family or herself. And what she said from the beginning was that she puts that gun outside, and within minutes after all that is texting her friend to go pick up the gun, that Gavin killed Destiny.
Oh, jeez.
So she's telling that story from the beginning. She explains to them why, when she tells them that story, that she didn't tell them in the beginning say that to the police was because she didn't want Gavin to live with the fact that he had accidentally killed his sister.
Then don't tell him.
There's been no proof that that's not true, that that wasn't her motivation. And she was telling people she told Mr. Key from the beginning. And Mr. Key, again, has raised, I should have raised that on the enhancements, that he said he met her through somebody else who Miss Howington sold pills to. Your Honor may recall that the Friday before that trial, he testified he knew her, he was introduced to her to do odd jobs around the house. And he did odd jobs around the house. And he got some pills. And then he comes to trial, so she says, how do you know him? Oh, as a drug dealer. That's not what he testified to at that hearing the Friday before the trial. That was not the first thought of Miss Howington. It was about that she paid him to do odd jobs around the house. But that part of the story that she was trying to protect Gavin was consistent if it wasn't the first statement she gave them, because she was still trying to protect Gavin at that point. She gives them the statement that an unknown black man fired a shot from the door. Clearly, she did not do that for racial reasons. Both of the fathers of both of her children, of those young children, are black men. She didn't have anything against black men. She's just trying to protect Gavin and keep them off of Gavin. Is that necessarily a rational concern? It might be if you got PTSD and you've just been through what she's been through. It would tend to make you irrational. The third mitigator we would submit is number 8, that she was suffering from a mental or physical condition that significantly reduced her culpability for the offense. And that, again, is just the same thing that I've argued before, is on the PTSD and what's happened that night in her home, and then being taken to the police department and abused by Detective Riddle in a way I've never seen happen before in any interview, or to that level. The last mitigator is that number 11. Although guilty of the crime, she committed the offense under such unusual circumstances that it's unlikely that a sustained intent to violate the law motivated the conduct. Unfortunately, when we look at what the medical examiner said, once that shot was fired, within 90 seconds at the most, that child, Destiny, was dead. The responding officer said, he tried to save her life, but by the time he got there, Destiny would have been dead. And he finally admitted that, yes, clinically, she was deceased. Clinically and in every other way by that moment. So it's a horrible thing, but for him, he did the best he could under the circumstances. So we would suggest, Judge, that there was, again, because of the way it's charged, even as a negligent act, it is hard to understand how you could negligently intend to violate the law in this matter, or that intent motivated the criminal conduct. It was this idea that she had a gun in the house and didn't know where it was. Had it not been for Mr. Oliver coming over and being upset that a boyfriend was there and taking the gun away from her, throwing it on the ground, and he testified. Callie picked it up, put it back together. She testified. Callie said, "What do I do with this?" She said, "Put it away." When they asked her in the police department, "Where do you keep your gun?" she told them where she kept her gun. She wasn't thinking, she hadn't had that 48 to 72 hours, that she didn't know where Callie put the gun. It was just a horrible circumstance on that particular day that led that gun to be where Gavin could find it. So we would say that if the court finds that there are, she has no prior felony convictions, and I think that's clear, and that there are no, if the court finds that there are no enhancement factors and finds that there is a mitigating factor, then we would ask the court to sentence her as a specially mitigated offender. It would reduce the sentence on that charge to 13.5, I think, and the lesser rate means nothing, but it's a constricted sentence under the statute that's still 85%. So that's what we would be asking the court to do.
All right. The state has, in their sentencing memorandum, urged that under TCA 4035-115 that consecutive sentencing should be considered by the court. As each of you are familiar and well versed in, that in this state, in order for this court to impose a consecutive sentence unless otherwise provided by law, that she has to meet one of the criteria within that statute. Which do you say are applicable?
So, Your Honor, if you don't mind, just because I did not get a chance to respond to Mr. Whalen's.
You don't need to. Let's go to consecutive sentencing.
Okay. The ones that we specifically say are, one, that the defendant is a professional criminal who has knowingly devoted life to criminal acts as a major source of livelihood, and 4, that the defendant is a dangerous offender whose behavior indicates little or no regard for human life and no hesitation about committing a crime. Oh, I'm sorry. I said 1. I meant to say 2 and 4. Okay. Yeah. I apologize, Your Honor. I meant to say 2 and 4, not 1 and 4. So 2 being that the defendant is an offender whose record of criminal activity is extensive, and 4 being that the defendant is a dangerous offender whose behavior indicates little or no regard for human life and no hesitation about committing a crime when the risk to human life is high. And so, Your Honor, I do just want to kind of touch on a few things that Mr. Whalen just said. First of all, when we're talking about Ms. Howington and all these problems that she is suffering, the only evidence that was introduced regarding her PTSD or anything else like that came straight from her mouth. We did not.
That's misstating the record. They went through her purse and asked her about every medication she was on, and it was all PTSD, psych meds.
Newsflash to both of you. I tried the case, and I'm very familiar with what the facts are. You don't need to address the enhancement factors. Make your argument on consecutive sentencing.
When we look at number 2, that the defendant is an offender whose record of criminal activity is extensive, there's case law that makes it very clear that that does not necessarily mean a defendant who has multiple prior convictions. The court can look to the criminal conduct in the case at hand when determining whether or not a defendant is someone who has a record or an extensive record of criminal activity. Again, Your Honor, when we look at this case, the defense wants to keep arguing this is a tragedy, this is an accident, all these things. I don't dispute the fact this is 100% a tragedy. The problem is the tragedy was caused by the defendant and no one else. They want to point the blame at the child's father, who was nowhere near when the shooting occurred. They want to point the blame at saying that she was raped, by the way, which, again, I'm not saying that she wasn't. I'm not saying that she's a victim. What I'm saying is that in that particular case, Your Honor, the person who she said raped her was convicted of false reports. That is all we know. And certainly, Mr. Whalen would not allow the state to get up here and call somebody who was convicted of false reports a rapist. So that's all I'll say about that. Again, every single thing that happened in this case was her fault and her fault alone. Not only did she, according to her own statement, leave a loaded and cocked firearm within reach of a 2-year-old for days. That was her testimony. Her testimony was that this happened days before, that Callie supposedly went inside, put it away. She never checked where he put it. She never did anything. But then a 2-year-old, again, according to her statement, a 2-year-old has the ability to find it within about 3 minutes. He was pretty small. The court saw pictures, measurements of him. He didn't take stools around everywhere and climb up like she initially claimed. That was not the case. This thing was sitting out where it was easily accessible to him. This tragedy was 100% preventable, and the person that should have and could have prevented it is the defendant. She's not the victim here. The victim is the 5-year-old child that died, okay? So not only do we have the issue of this defendant being just careless and negligent as far as it goes with the gun, it's her actions after her daughter is shot that we urge the court to consider.
All right, thank you.
And also, well, I guess that kind of goes in with the behavior indicates little or no regard for human life. A lot of that does. There are just a couple of other things that I do want to bring to the court's attention. Sorry. Again, we talk about the detectives beating up on her and everything like that. Your Honor, we all saw the video. The detectives absolutely did say they suggested Antoine first, okay? No doubt about that. The fact of the matter is, she knew good and well that Antoine had nothing to do with it. She could have persisted in saying no. That's all she had to do. She didn't have to continue to make up story after story after story. She didn't have to pick him out of a lineup. Mr. Oliver could not go to his own daughter's funeral because she had literally framed him for murder. When she took that stand, and I asked her that, her words verbatim were, Antoine didn't matter. That's what she said. Those were her words. I didn't put those words in her mouth. The detectives didn't put the words in her mouth. Those were her words on the stand. She did not care about him whatsoever. She didn't care. She didn't care about anybody in this case but herself. This was not about protecting 2-year-old Gavin. All of her lies were not about protecting Gavin. If she wanted to protect her son, she should have done that before he got a hold of her gun. So for all those reasons, Your Honor, in this case, we are asking the court to not only give the maximum sentences, but we are asking the court to order consecutive sentences based on those factors.
All right, let me hear from, is Mr. Oliver going to be the only victim impact statement?
Yes.
Let me hear that.
I do have some argument on it.
Folks, the case law on this is very clear, and I can do this for show, but I don't operate that way. It would never stand up on appeal in this court's humble judgment to sentence her consecutively. Let me hear from Mr. Oliver.
So Your Honor, he does have a victim impact statement that I'm going to read.
You're going to read it?
I'm going to read it on his
Okay.
Your Honor, I have a lot to say. I beg the court in diligence while I speak my piece because I've found over the years I'm not always afforded an opportunity to say stuff, and I must speak the truth. So this time, if for no other reason than that, this court is going to hear the truth. I can't speak for anybody else, but I can tell you if nobody else says it, I'm going to speak the truth, and this is it. Who knew that on September the 12th of 2019, that would be the last time that I got to see and spend time with my beautiful daughter, Destiny Jariah Oliver. She was absolutely the true definition of a daddy's girl. All Destiny ever wanted was to be with her daddy. Robin was jealous of our relationship, and she couldn't stand it. Destiny was the best daughter that any father could have asked for. I was so excited to surprise my daughter and to have the opportunity to pick her up from school that Thursday. Her face always lit up when I arrived to get her, and that day was no different. I always made plans of doing a lot of fun activities with her after school when I was able to get her. That day was different, though. It was very special. First, we went and got food from her favorite place, Chick-fil-A. Next, we continued our journey to National Fitness Center off Walbrook Drive in Knoxville. She went swimming, and she also did rock climbing that day. After a few hours, we left there and went to Brewster's to get ice cream. We ordered our ice cream and sat on the bench and enjoyed it together. As we sat there, I looked at my baby girl. I knew something wasn't right, but I couldn't put my finger on it. We talked about what she wanted to be for Halloween and what she wanted for her 6th birthday that was coming up that was less than 4 weeks away. But that moment was extra special as I stared into my daughter's eyes, not knowing that it would be the last time of having her in my possession. My last time being able to do anything with my precious daughter. We left West Knoxville and headed back over towards Fountain City so that I could take her home. As I got closer to Broadway, Robin called and asked if I could go to Party City to get a costume for Destiny for school. We had a few words. At that point, I knew that she was trying to cause problems. I hung up on her and went to Party City and let Destiny pick out her costume for school. Shortly after that, we arrived at her house. I got Destiny out of my vehicle, and as I approached the door of the house, Robin came out of the house and instantly started attacking me. I tried to deflect the blows that she was throwing. Then her boyfriend came outside, and I asked him to get her, but he refused. He then closed the door so that the kids couldn't see what was going on. Robin and I had a few more words before she went back inside and came back out with a gun. I asked her, "What are you going to do with that?" And she said she was going to shoot me. I noticed that she really didn't know what she was doing, and the first chance that I got, I grabbed the gun and disarmed her. I took the clip and made sure that no round was in the chamber.
Look at that face she's making.
I was going to throw the gun on the roof of the house so that she couldn't get to it, but ended up tossing the clip in one direction and the gun in the opposite direction so that they would be far apart from each other. Robin then ran back into the house to get something else. I didn't know what she was doing, so I got back in my vehicle. She came back out with her cell phone, threatening to call the police on me. She asked her boyfriend, did he find the firearm, and he said yes. She then proceeded to try to open the door of my vehicle, yelling and screaming at me. I rolled my window down and told her boyfriend that he needed to get away from her because she's trouble, and that he had no clue that she was a psychopath, and then I left. To this very day, I wish that I never had taken Destiny back over there that Thursday night. Robin then called me early Saturday morning as if nothing happened Thursday night. I did get to speak to my daughter on the phone, but it was not long at all. Robin took the phone from her and proceeded to talk as if nothing happened. I told her she was crazy, and then I hung up on her. I didn't speak to her anymore that Saturday. I didn't find out about Destiny's death until the next day, which was Sunday, and was told that she had passed away. The grandmother called and told me that Destiny was dead. I couldn't believe what I was being told. It was the worst day of my life. My family and I went straight to the Knoxville Police Department to find out what happened to Destiny. I wanted to make sure that I wasn't being lied to. I spoke with an officer. He asked me a few questions about my whereabouts Saturday night, and shortly after that, he said that I was the one who had killed my daughter, which was false. I wasn't even in the city when my daughter had died. I was told to come back the following day to speak with detectives. I came back in the next day, which was Monday, and I was interrogated for quite some time. The detectives wanted my cell phone so that they could search it and invade my privacy. I was humiliated, yelled at by these detectives, and then accused of killing my own daughter in cold blood. I couldn't believe what I was going through. Here I am, a grieving father that had just lost his daughter and being blamed for killing her. I was threatened multiple times that if I didn't give them my cell phone, that they would hold me and lock me up. I ended up giving it to them and still haven't received it back to this day. 2 days after the interrogation, they got a search warrant and kicked in my door and raided my residence. They told my landlord that I was wanted for murder and that I was never coming back because I was going down for killing Destiny. My landlord thought very highly of me until that day, and he wanted me out of the house immediately. Unfortunately, I wasn't there at the time of the raid, and that was the same time as my daughter's funeral. I wasn't able to attend the funeral because of this situation. They really ruined my entire life while I was still trying to process the death of my baby girl. I was unable to get all of my belongings from the house. Some items were stolen, some items were also left behind. I ended up spending a lot of unnecessary funds on attorney's fees because I was being accused when I was completely innocent and had nothing to do with any of it. Your Honor, this woman has caused my family, friends, and I so much pain and heartache. She has been a very violent individual. In the past, she tried to have my ex-girlfriend kidnapped and admitted that to me. My ex-girlfriend had to purchase a gun for protection because of Robin. Robin has vandalized multiple vehicles of mine. She's vandalized one of my other friends' vehicles that was parked outside of my place.
Ron, this goes beyond the scope.
I can consider it only for the purposes of victim impact statement. It's not evidence that will be within the record.
I've lost thousands and thousands of dollars that I've invested over the years because of this lowlife. She has harassed me by following me and popping up at my house at all times and stalked me for years because I didn't want to be with her and she couldn't stand seeing me in a relationship with someone else. She broke into my house and stole a lot of valuable items previously. She has lied and made false reports numerous times. One time she even called the police and told them that I was kidnapping our daughter one night. She had the whole entire police department at my house for nothing. She's threatened to have my mother's brains blown out. She's also said that she knew people that didn't have a problem with killing a kid. She even called DCS on my son's mom for no reason, trying to get her children taken away from her. This woman should have been taken off the streets years ago and put away behind bars, but she lies and manipulates the system and always manages to slip away without getting in trouble. This woman is a real piece of work, as you can all see by now. This isn't even a fraction of all that she's put me through. Robin used my daughter to get at me any way that she could. Sometimes she would go weeks without letting me see and talk to Destiny. There were numerous times that Destiny cried and cried because she didn't want to go back home with her mother. As of October of 2017, Ms. Howington Robin had lost custody of both Destiny and Gavin. They awarded custody to Robin's mother. I knew nothing about this. No one contacted me about the situation at all. I never knew anything about these court dates. I didn't find this out until March of 2019. I went to pay child support and happened to ask for any and all documentation filed on Destiny because I was seeking custody of my daughter. They printed out numerous documents, and this is how all of this was revealed to me. After 2 years of me not knowing any of this, it was finally revealed because of my actions. I found out that Robin had a real bad drug habit, and she'd lost custody of Destiny because she kept failing drug screens while she was pregnant with Gavin. The court awarded the grandmother custody without my knowledge. Even when Destiny died, the grandmother was there supervising the kids, was supposed to be there supervising the kids because she was appointed to do so. Robin wasn't allowed to have the children unsupervised. The grandmother violated a court order and failed us all, as well as the state, because they shouldn't have been awarded custody without each of the fathers being evaluated and looked at as having custody of their own children. The state would have done their job correctly, my daughter would have been in better care and would still be alive today. Robin is negligent. She cared nothing about her children. She made up multiple lies years back and had me arrested. I had to enter a best interest plea just to keep from going to jail. I provided video evidence of her actions. She has been the aggressor this entire time, telling me that she's going to have me put in prison somehow, some way. Even in this case, she told law enforcement that I was the one that had killed my daughter. I am the victim here, and she needs to be put away forever. She lied historically and used the state of Tennessee as a weapon against me and everybody else, and attempted to do the same thing in this case. In the past, I've shown videos that I've taken surreptitiously to have to prove that this country isn't premised on proving our innocence. I've had to prove my innocence all because she is a woman, but in reality, she is a lowlife and cared nothing about Destiny or her other children. The only thing she cares about is herself. She lied repeatedly in this case. She's culpable in it. Robin is the reason that my daughter is dead. It is my desire to see her rot in prison. I want her to be there for the rest of her life if possible. If not, I beg the court to give her the maximum sentence possible. She deserves to die in prison. She is responsible for the death of one of the weakest in society, a small, innocent child who was defenseless and had no say in what her mother did and put her through. Yet she did it over and over, and the state turned a blind eye to it. She deserves to die in a prison cell somewhere. That's what I'm asking, to put her in prison for as long as you possibly can. She's a liar. She's a manipulator. She's responsible for the death of our daughter. Robin is a poor excuse for a human being. She again, is responsible for the death of a child, someone who didn't have any say-so in what was going on. She manipulated the courts in this country and punked everyone here for years, making up lies about me. Again, I've had to enter a best interest plea, and my attorneys have had to show videos that I've taken to prove my innocence. I've had to prove my own innocence, and that's not how this country was founded. That's not what our Constitution is premised upon. But I've had to do that because she is a master liar and manipulator, and used this court and every court in this country to her benefit to get even with me and to accomplish her will, all because I didn't want to be with her. Even during the course of this case, she's lied through her teeth and said it was me that was responsible for this horrific tragedy. I ask this court to give her the maximum sentence possible. It is my desire to see her spend the rest of her life in a prison cell. Because of Robin, I have no daughter now. At a minimum, I desire for her to be put away forever. I'm asking for consecutive sentences, maximums on every charge ran consecutively so that she never comes out of prison. She is a poor excuse for a human being. That is what prisons are made for, is to keep people like her who victimize anybody that they can for their own benefit. I'm asking you to keep her in there forever. If you can give her a life sentence, Your Honor, that still wouldn't be enough. It's my desire to see her go away for the rest of her life. It's my desire to see her die in prison. You know what else she did? She blamed it on her 2-year-old son for the death of our daughter. She is a despicable human being. Not only did she victimize and cause the death of our daughter, she further victimized her own 2-year-old child by blaming him for his sister's death. Your Honor, I am begging you to give her the longest and maximum sentence that you possibly can string together.
All right, thank you. Ms. Howington, this is your opportunity to speak before the court makes certain findings and pronounces judgment. In this case, you're not required to, but this is your opportunity if you wish.
Oh, no. Okay, good.
All right. The court is tasked pursuant to TCA 40-35-114 and TCA 40-35-113 to first find whether enhancement and mitigating factors which are confined to these two statutes are applicable. The state urges a number of different enhancement factors. There's a couple that I'm going to rely upon because I think they're just glaringly obvious in this case. And while I could find perhaps other enhancement factors, I don't think there's any point in muddying the record up on appeal with going into those, because there's no specific set of enhancement factors. There's no calculus or graph that the court has to follow as far as I can only go up so far if I find 1 versus finding 5. That's not what the law says. Ms. Howington, this is a strange case. This is one of the more unusual cases among the hundreds that I've tried as a lawyer or as a judge. But there are a couple of things in this case that are just glaringly obvious. I agree with what General Good just said a few minutes ago. You are not the victim in this case. You have a previous history of criminal convictions or criminal behavior. What you had before the night that this tragedy occurred was not very significant, although you were engaged in the trafficking of illicit narcotics, and the court can consider that. But I really don't know how you could have made this much worse than what you did that night. Within literally minutes of when your daughter had been shot and killed, you were attempting to hide the firearm that was used to kill her. You're not concerned, you weren't then, you're not now. You're not concerned with trying to protect Gavin. You're concerned with trying to protect Gavin's mother. And you have been, you were that night, and I will believe that from this point forward. I don't know how you could interpret this evidence any other way. You have a previous history of criminal conviction, criminal behavior. You tried to hide the gun that was used to kill your daughter while her body was still warm. When you were taken to UT Hospital to be checked for shock before you spoke with law enforcement, you attempted to solicit another person to take your cell phone so that it couldn't be looked at, and then you tried to destroy the cell phone. Within seconds, if not minutes, of when your daughter was shot and killed, you're calling 911 and making up a story about how it all happened. And repetitively, I quit counting at about 20, repetitively throughout hours worth of police interviews, not just that night, but on other occasions as well, you made up story after story after story. And this court can consider every bit of that as criminal conduct. So you clearly have a previous history of criminal convictions or criminal behavior which enhances your sentence in this case. As to count 2, the aggravated child neglect where there was serious bodily injury, count enhancement factor number 9 applies as well. A firearm and your handling of that firearm is the reason that your daughter is not here now. It's not because Antoine Oliver showed up 2 days earlier. It strains the bounds of credulity to believe that your boyfriend just laid that gun down where a small toddler could just walk in within 2 or 3 minutes after you and your children arrived home, found the gun, pointed it at your daughter, and pulled the trigger when that gun had been in that same place for 24 to 36 hours and nobody saw it. I will never believe that. And I don't think you were honest with the jury about how that happened. But the simple fact remains that however he found it, you were responsible for that gun. What I believe happened, if in fact it was your child that had the gun, when the bullet was fired that killed your daughter, there was a man that came in. And I don't know if it really was somebody to collect window tint payments like you testified to, or if it was a pill deal, but somebody came in. It was a strange man in your house, and I believe you had that gun out for protection. I believe you had a round chambered and the safety off, and that gun was left there, and when you stepped out to smoke, the tragedy occurred. But that's on you and nobody else. So I place great significance on the 2 enhancement factors that I found. Your history as well as the firearm use in this case. As stated previously, the mitigating factors, this was an unusual case. There are unusual circumstances, but I don't place much weight on that as far as mitigating your punishment. So if you would, please, ma'am, stand up.
Woo.
Ms. Howington, in docket number 117659, based upon the jury's verdict of guilt, finding you guilty in count one of the lesser included offense of reckless homicide, you were found guilty of that offense and sentenced to a term of 3 years to serve within the Tennessee Department of Correction as a range 1 offender. In count two, based upon the jury's verdict of guilt, finding you guilty of aggravated child neglect, you were found guilty of that offense and sentenced to a term of 22 years to serve within the Tennessee Department of Correction as a range 1 offender. In count four, based upon the jury's verdict of guilt, finding you guilty of false report, a Class D felony, you were found guilty of that offense and sentenced to a term of 3 years to serve within the Tennessee Department of Correction as a range 1 offender. In count five, based upon the jury's verdict of guilt, finding you guilty of tampering with evidence, a Class C felony, you were found guilty of that offense and sentenced to a term of 5 years to serve within the Tennessee Department of Correction as a range 1 offender. And finally, in count six, based upon the jury's verdict of guilt, finding you guilty of attempted tampering with evidence, a Class D felony, you were sentenced to a term of 3 years to serve within the Tennessee Department of Correction as a range 1 offender. These sentences will be served concurrently, one with the other, for a total aggregate sentence of 22 years to serve within the Tennessee Department of Correction. And as your attorney has pointed out, the service rate is at 85%. I wish we weren't here. I know you wish you weren't here. Mr. Oliver wishes that we weren't here, but you're the one responsible. That'll be the judgment of the court. Good luck to you. When do we need to set this for motion for new trial?
We'll need a transcript. I suspect that's going to take.
That's going to take a while. She's really backed up. I mean, why don't we set this out about 5 to 6 months just for status on, see where the transcript is, and then we'll set another date, a firm date for motion for new trial. Let's look at, what's the first Friday in September?
The 6th.
What about Friday, September the 6th? Is that a good date?
Yes.
All right, 9/6 for status, and then we'll be sure and get your motion for new trial filed within the next 30 days, Mr. Whalen.
Yes.
Thank you, Your Honor.
So 22 years and 85% of that is mandatory. So 18.7 ML says. 18.7 years. Whew. I mean, that judge telling her, okay, first of all, let's talk about that letter. Baby daddy couldn't wait to get all that out. All the stuff about what all she's done and the chaos that she's caused. That was wild. He said she should not be on the streets. She should have been off these streets a while back. That was wild. The judge, I'm glad that he talked to her in a way that was like, he was firm, but he was fair, I think, personally. She's 41, so she will be 59 or 60 when she gets out. Man, I feel bad for that little baby. That's really sad. Yeah, he did what the law allowed him to do. I think I think he did great. you know, like I think it's good when they're firm like that about things, because it's, you know, that's the thing is like he went exactly by the evidence. You know, sometimes like I know that some judges will be a little bit over the top with it, you know, and let emotions get in. But I don't think that he, you know, did that at all. I think that he was great with, you know, pointing out that like this is a tragedy that is, you know, that you brought on by your actions. And I think that he's absolutely right. I think that, you know, having that, having the gun out, you know, while she's doing her drug deals and all that, like, that's more than likely how this happened. And it's so terrible. I feel, and every time I think about this case, I will always think about Officer Cummings breaking down on the stand. He just touched our hearts so much. It was so sad seeing him, you know, that, of course that's going to impact them. But he's right. I mean, within seconds of this tragedy happening, she's on the phone with 911 making up lies. She wasn't concerned about protecting her child. She was concerned about protecting herself. And I think that's so sad. It's so sad. And it, you know, having strange men come into your house where your young children are to buy drugs from you is dangerous. So, I mean, having the gun, like the judge was saying, like having the gun to, you know, protect yourself from that. Okay, but it's not protecting yourself if you leave it out for, you know, or it's not protecting anybody if you're leaving it out for them babies to get it. So, it's a sad situation all around. I am, you know, I feel really bad for her son because she lost rights to all of her children at one point. I feel bad for the son because, you know, now he has lost his sister and essentially his mom. And, you know, ugh. So sad. So sad. Yeah, you don't have firearms within reach of children. That's like, I mean, that's like gun safety 101. I think, for me personally, okay, if she had made that tragic mistake, okay, yes, you are going to have to, you know, serve time for it. You're like, if it weren't like, you know, oh, I had a gun out because I was doing a drug deal with my, you know, young children, and it was, you know, like just if they had gotten to it somehow and, you know, whatever, I think that I would be, and if she were immediately, like after that happened, if she were immediately like, oh my God, you know, what have I done? Like, I'm so, you know, like just to be remorseful and stuff, I think it would be a little bit easier for me to feel the type of empathy for her that I would normally feel for any, you know, mother who's lost a child. But the fact that she has taken no responsibility for anything and has blamed literally anyone and everyone else that she could possibly blame in hopes that something would stick and one of the, however many it was, 9 to 12 stories would be believed. That's the part that is so frustrating. Was it her? So this is something that we did a couple polls on this when we were watching this trial. There are some, oh, what just happened? Did I lose y'all? Did I lose you? Oh, it just kicked a whole bunch of people out again. See how many it kicked out this time. Let's say about 200. I don't know why it does that. So we did a poll on this last time, and it was kind of split. Yeah, mine did the same thing. It said chat disconnected and then reconnected, and then my numbers show that it kicked off like 200 people. YouTube be YouTubing. So it was kind of split. So a lot of people thought that she's the one who pulled the trigger because there was a question about whether or not little baby Gavin would be able to even pull the trigger. So some people thought that she did it. You know, there was a small percentage that thought that she did it purposely. Most people thought that she did it accidentally, like maybe moving the gun around or just having it out or something. And then some people thought that she did. Let's do a poll for those of you who watched it. We'll do a poll. I don't remember what the percentage was last time. How do you think it happened most likely? It was split though. Robin intentionally. Robin accidentally. Gavin. Or third party from her stories. Any of the third parties from any of her stories. The hard part that I think we were all having trouble with is whether or not the baby would be able to pull that trigger, because I think it was like 8 pounds of pressure that are required to pull that trigger if it's not already racked. So, or if I think that was if it's already racked. If it's not racked, then it was more. I can't remember the pound that they said for that one. So just having, you know, and like, oh man, the pictures of that little baby. I mean, he's only 2 years old. He was tiny. And seeing him and his little bitty self and his little bitty hands, it's just hard to picture him being able to pull the trigger. And I'm not saying it's impossible, but to be able to hold the gun, pull the trigger, it was something that, you know, there were definitely questions about. Yeah, and there were people who thought that it was, the people who thought that she did it intentionally, it was mostly, you know, because, I mean, sister got a screw loose, let's be honest. We can tell that from a lot of the stuff that she's done and said. Sister's got a screw loose. So I think a lot of the people thought that it was to get back at the, you know, the dad who she is obviously has a very toxic relationship with or toward or whatever. But poor little baby Gavin. Yeah, guns in the hands of responsible people is a different beast altogether. You know, that's the thing, is like, I'm from Georgia, y'all. Even my nanny's a member of the NRA. We do guns around here. But it's been taught from the time I was itty bitty, like, there are, you know, like, there's safety rules that you don't mess around with at all. Like, you know. So to leave a gun laying around with children is, I mean, it's that, yeah, it's not, it's oh, it's so bad. I just feel, oh, my heart breaks for Gavin. It really does. It really does. All right, so let's see. Let's change gears a little bit. Change gears. My girls have their own firearms. They took the hunter safety course when they were young. Yeah, like I grew up, you know, my daddy hunted, and my daddy had a big old gun collection. My family's like, it's always been, it's not like having guns just to have guns. It's, you know, protection stuff, but also growing up, it's hunting. Like I lived out in the country. Like we, you know, my daddy'd shoot a deer, my mom would cook it. So, all right, let's see. Let's swap gears a bit. All right, so yesterday.
And admonishment.
I have to, oh man, I'm gonna have to pull this up. Let's see, the, what was yesterday? Day 5, 6, 12? What was yesterday? April 18th. Yesterday was day 6. We're going to watch that spicy hearing at the very end. Okay, so remember, for those of you who weren't there this morning, we were talking about it. Remember, we talked about on Easter Sunday, there was a motion that was filed by an attorney who we were like, was he like drunk and confused? Was he like, what's happening here? An attorney who all of a sudden said he's representing Daybell. So yesterday when we had to end, or when the court ended and they were having that hearing, that's what the hearing was. So I wanted to watch it together since we didn't get to watch it yesterday. And the judge gets super spicy. So we're going to watch that. It's not real long.
Are you willing to answer those?
Sure am.
All right. The pleading I'm looking at, it's not been entered in the case yet, and the pleading, give me just a second.
The intervener. All right, I'm going to end our poll so we can look at our results too. All right,
you did in fact.
59%, before we get into this, 59% of y'all think that Robin did it accidentally. 32% believe that Robin did it intentionally. Only 5% believe that it was Gavin. And 2% of you accidentally hit third party from her stories. I'm just joking. If that's what you think, that's fine too. But that was the votes.
In fact, file this electronically in CR. Well, that's wrong too, the case number, but this is case CR 22-21-16-23, the state of Idaho versus Chad Guy Daybell. Is that correct?
That's correct.
All right. I'll note the case number is wrong as well. You've got it CR 12-21. The first part I want to know under Rule 11, which requires you to make representations to the court, you hold yourself out as, entitle yourself attorney for the defendant. Why do you say that?
Judge, as you know, this is a template form, and I simply forgot to take that off of there. That was Scrivener's error on my behalf.
Okay, Scrivener's error. On the
If you notice in the body of the motion, Judge, I say without permission of the defendant or his trial counsel.
All right, let's look at your signature on page 3. You signed Terry S. Ratliff of the firm, attorney for the defendant, on page 3, don't you?
Again, because it was in my template.
All right, on page 2, again, a signature, Terry S. Ratliff of the firm, attorney for the defendant, correct?
I don't have a page 3, Judge. I just have a page 1 and 2.
The bottom of the certificate of service is one signature, another at the bottom of the contents of the pleading.
If it's there, Judge, it's there because it's a template form and I didn't strike it.
Okay, so 3 times you called yourself the attorney for the defendant. So who are you the attorney for?
Me.
So Terry S. Ratliff, attorney for Terry S. Ratliff in this case.
I should have signed citizen.
Citizen?
Yes.
Why are you
Avoid-
referencing your bar number if you're just citizen?
Again, it's the form, Judge. It's a reference to the form. I'm not Mr. Daybell's attorney, never was.
You put this on a pleading. If you look at the top left, you've got your name, your Idaho State bar number, your Ratliff Law offices, and attorney for defendant. You're telling me you mistakenly just wanted to file something as a citizen and not as a lawyer?
I was looking for immediate relief because of the concerns I had about the case, Your Honor.
And why were you doing that on a Friday night at almost midnight? What, you've known about this case for a long time, according to your own content here, right?
That's correct.
So why are you doing it then?
Because I thought I needed to do something to slow it down.
Trial scheduled for how many years? And you wanted to slow it down the day before trial started?
I'd also gotten calls from Mr. Pryor, Judge, for help.
That might be fine, but did he ever retain you on the case, or did you ever enter an appearance for the defendant?
I did not.
All right, and you do state in here you're filing this pleading without the permission of the defendant or his counsel, correct?
That's correct.
You also state in here and call yourself an intervener. What basis do you have to intervene?
Based on my,
On the brief?
yeah, it's set out in our brief, Judge, as to the basis for why I wanted to intervene. In the motion, I quote you the relief I wanted. I give you the grounds on page 1 as to why I wanted that relief and why I thought it was necessary.
Okay, and you're going to intervene now not as Terry Ratliff lawyer, Terry Ratliff citizen at large?
I think it's semantics, Your Honor.
Oh, boy, let me stop you there. It's absolutely not. A bar licensed attorney filing something with their bar number to the court is completely different than a citizen. That is not semantics. This is what brings you within the auspices of Rule 11.
I understand. I said perhaps I should have signed it as a citizen, but I didn't.
All right. In your intent to intervene, whether it's as a citizen or an attorney, let me read you a couple of case quotes. Quote, "The Idaho rules of criminal procedure do not provide a process for intervention. The inability of non-parties to intervene in a criminal case recognizes that the considerations underlying intervention in civil cases are not applicable to criminal proceedings." That's People versus Ham, and that's State versus Johnson, 167 Idaho 454. And we've also got another Idaho case citing, quote, "Petitioners are correct that Idaho's rules of criminal procedure do not provide a specific mechanism for third parties to intervene in a criminal case." So again, I think there's settled case law that prohibits intervention in a criminal case. And I'd like to know what authority you have that says you have a right to intervene either as an attorney or a citizen in this case.
As outlined in our brief, Judge, sorry about that. As outlined in our brief, we have given the court several cases where the Idaho appellate courts have allowed people to intervene in cases in a criminal matter, even though they're not parties. That's my basis.
So you intervene, and then we've got 2 parties here. We've got the state, we've got Chad Daybell, and you're going to float around and be what if you intervene in this case? What are you going to be?
I'm not going to be floating around this case, Judge, because you haven't granted my motion.
Well, assuming you got to intervene, you assumed in your motion you did intervene because you called yourself the intervener once you got going in your motion. What were you going to be at that point?
I was hoping to have a hearing in front of you before the trial started.
Okay. And you said you were going to be the lawyer for the defendant or already were the lawyer for the defendant. Is that?
Not. I explained to you just a few minutes ago that that was a mistake.
Explain to me all of the misspellings and typographical errors in your late night filing.
I was nervous and it was late at night. I didn't take this lightly.
You didn't take it lightly, but you used the wrong form. You misrepresented if you were an attorney or a citizen and you signed 3 times as attorney for defendant. And that's your explanation?
Yes.
All right. Mr. Ratliff, I find based on your responses, you have violated Idaho's Rule 11 under the Rules of Civil Procedure, which I find are incorporated through Idaho Criminal Rule 47 and 49. The court would note that in the rules under C1, it's mandatory. It says the court must impose an appropriate sanction on an attorney, law firm, or party that violated the rule. And similar to what would happen in a civil case with a frivolous type filing, which this was, this cost time, this cost effort, this cost real loss for the attorneys, for the court. I'm going to instruct counsel for both the state and the defense if they could itemize the time they have spent both in today's hearing, in preparing for the hearing, as well as in dealing with this pleading from the time it was filed on Friday night, the 29th, whatever time you've put into that. I'm going to direct Mr. Ratliff that you pay reasonable attorney fees incurred for the time Mr. Pryor spent at his typical hourly rate for the state's attorneys and whatever rate they are entitled to charge as public prosecutors. And the court will likewise itemize some billing time incurred in this. And the sanction the court's going to order is the payment of those attorney fees. The court will provide time for counsel to submit those. I'll review those for reasonableness before I make an order. And pursuant to the rule, which requires a written order under Rule C6 of Rule 11, the court will describe in that order the conduct and the basis for the sanction, and you're going to pay for those fees. Do you understand that, Mr. Ratliff?
That's fine, Judge.
Very well. That'll conclude.
Your Honor, if I may, I'm going to request findings of facts and conclusions of law. As this court is aware, we submitted briefing that addressed many of the issues you addressed to Mr. Ratliff in great detail, giving multiple basis for his right to intervene. The judge, you have not addressed those arguments, and so I'm going to ask for findings of fact and conclusions of law.
All right. Well, Mr. Bartliff, you can ask. I'm not inclined to do that because, again, I've got a lawyer in front of me that submitted a pleading, and the lawyer is responsible for the pleading. I'm not necessarily allowing any further input on behalf of counsel for the lawyer that filed the pleading. I don't think it's proper because I'm not imposing any kind of jail time or sanction similar to Rule 75 of the civil rules, which would implicate on a contempt proceeding the right to counsel. So I'm going to stand by my ruling that I made and ask the attorneys to submit those. That concludes the matter for this afternoon.
Judge, if I may. I'm sorry, Judge, I am
not. I'm done. I'm done with this issue, and I'm done wasting time on this issue in the middle of a capital case. We're done. We're in recess, period.
He sounds so mad. Lord of mercy. Okay, so something that just popped up. He said, "No, you may not." He said, "Nope, denied." Something that just popped up. I'm about to see if I can. Dang. is not, for the scanner is not working. There's a Florida, it's always Florida. It's always Florida, y'all. There's a guy on the run because apparently, I'm trying to see, they just had the helicopter following him, but I guess the helicopter had to go refuel. I'm looking now to see if there's any other coverage, maybe not. He apparently was wanted for robbery or something, and I think they stopped no more helicopter coverage. Dang! He apparently was wanted for armed robbery or something, or some kind of robbery, and there was a traffic stop. They attempted to stop him, and he tried to like ram the police car, and now he's on the run, and so they had like helicopters and stuff following him. And I was trying to find it, but they ended the helicopter coverage, and then I was trying to find the scanner, but they have the scanner, that county doesn't have their scanner working. Let me see if I can find. Deputies are combing a wooded part of Pasco County after a suspect ran a Hillsborough deputy off the road and fled. Let's see if I can find. Oh, oops. Oops. This is from Facebook. Hold on, let me see if I can find Hillsborough. Hillsborough. See if we can find anything on it. Failed traffic stop. This is not the. Hold on, let me see what I can.
Rescue 16 hospital. Rescue 3, difficulty breathing. 5126 Range Lane, across Broadway, 1249.
Car vehicle.
Live from the Stream Center, breaking news.
That got real loud. Like real loud.
Eagle 8 HD over
This is what they said about
Pasco County near the Tampa Premium Outlets as they search for a suspect after a failed traffic stop this morning in Hillsborough County. We just got an update here to WFLA.com into the newsroom. Hello there, everybody. JB here with you live on stream with Eagle 8 in the air above Pasco County, north of Tampa, Florida. I'm going to read this release here as follows. On Friday, April 19th, 2024, at approximately 10 a.m., an HCSO deputy attempted to conduct a traffic stop on a Ford F-250 that was involved in a burglary earlier this week as well for a traffic infraction. The vehicle did not stop and attempted to ram the HCSO deputy's vehicle, causing the deputy to swerve off the road. With assistance from the Florida Highway Patrol and the Pasco Sheriff's Office, HCSO followed the truck northbound on I-75 to State Road 56. The suspect then fled on foot into a wooded area. HCSO's aviation and K-9 units are currently assisting with the search. And that's where we have the search efforts ongoing right now for this suspect. There's multiple aircraft in the air in this area. We have, of course, seen Hillsborough County Sheriff's deputies' vehicles. We have seen Pasco Sheriff's Office vehicles. We've seen Florida Highway Patrol. I think that might have been a drone I just saw. There's a helicopter in the air with local authorities as well. So this is developing at this hour. But with the suspect fleeing on foot, clearly fleeing on foot in an area that is challenging for deputies because it's so dense of a wooded area, again, near the Tampa Premium Outlets on State Road 56 in Pasco County, Florida. There is that chopper I mentioned a short time ago. And we're going to pass along any new details and developments as they come in. So a burglary suspect in a Ford F-250 pickup truck then rammed a deputy's vehicle after a traffic stop for a traffic infraction, as well as being, I'm sure, wanted for the burglary. The vehicle then leading a pursuit up north on I-75 to State Road 56, and then the suspect ditching that truck and fleeing on foot into this area. So I'm going to try to give everybody an updated location as to where we are and what we're looking at here specifically. But this is near State Road 56. And, or excuse me, that might be State Road 54. Well, this is off of State Road 54.
Off of State Road 54.
And this is off of I-75, really on the west side of I-75, in the area of Twin Lake. The wooded area that they're focusing in on, by the way, as I zoom in here, this is the outer fringes of the Cypress Creek Preserve, an area that it's obviously a wooded area in Pasco County. So there you can see the deputy vehicles. I'm curious to see if we can see that pickup truck. Again, it is, did they give us a color? They did not give us a color. It was a Ford F-250.
It's always Florida, y'all.
And again, that Ford F-250 ramming a deputy's vehicle, according to the release. Or, I'm sorry, let me clarify there. So they say that the vehicle didn't stop as a result of the traffic stop and attempted to ram the deputy's vehicle. Now, that caused the deputy to swerve off of the road. By that point, you would imagine that the deputy is radioing in to all law enforcement in the area, and that's when this became a pursuit that went northbound on the interstate. So I-75 is one of the, if not the most significant thoroughfare through the Florida Peninsula. And so this pursuit might have been seen by a lot of folks on I-75. And if we don't know exactly where the traffic stop was. So we don't know how long this went on I-75 and how north this actually, or how long this pursuit was on I-75. If this was something that went over a period of 15 minutes, or if this is something that was, extended beyond that. Also, I'm not sure as the traffic conditions going northbound on a Friday, 12 o'clock. Well, it happened at 10 a.m. So Friday, as someone who's on the interstate quite a bit, Friday, northbound,
See, I'm looking to see.
I-275/I-75. Chances are the roads were clear enough for this person to whiz by regular traffic.
I know they said that they had the chopper that's
So
going
Eagle
to.
8 HD is participating, obviously, in this search. And as a reminder, Eagle is navigating around with other air traffic as the search unfolds for the suspect. If Eagle were to see anything of note, something that catches the attention of our pilot or our photographer, Joey Capistrand, who's in Eagle 8 HD for us today, that we radio in to authorities. And we, of course, let them know that what we have observed. There you can see, I believe that's Pasco Sheriff's deputy cruisers. And again, trying to find that Ford F-250 that the suspect is said to have ditched. And actually that's it right there.
Oh.
So there's
There it goes.
Ford F-250. A lot of stuff in the bed of that truck.
They said he took off on foot.
Looks like some Yeti coolers and a couple of other items.
How are you going to ditch the Yeti coolers? Especially in Florida. We need them around here. Pasco County has been on patrol.
So there's the Ford F-250 that was involved in this attempted ramming of an HCSO deputy vehicle around 10 o'clock this morning, according to the release, and then fleeing northbound to here in Pasco County. So as far as exactly how far, I'm curious as to how far this is from the outlets, because the outlets are a main, especially I would imagine on a Friday, they're going to do a good amount of traffic at the Tampa Premium outlets. So if we do just a quick little Google map search, and we look here between the 2 points, really this is the focus point is on
ham radio is all it has.
Here, let's see here.
I was trying to see because they have.
This is the greater Land O'Lakes area, by the way. So this is really just 3 or 4 miles away from the Tampa Premium outlets. The Tampa outlets are located right off of I-75 on the west side. Great spot where people go to shop, grab lunch.
Great spot.
It's a busy area. Those intersections there are massive, and it's a lot of traffic. So if the truck pulled off of I-75 and went westbound on State Road 54 before, ditching the pickup truck, that's going to be seen by a whole lot of people. Facebook Live, especially because we have a lot of people that join us locally on Facebook Live. If you saw this unfold or you caught a portion of this pursuit, I'd be curious as to what you saw. Let us know.
Tampa. Let's pull. Yeah.
Let's go full screen here and see what Eagle 8 HD is seeing.
Dang. They don't have oh, there's one. They don't have any choppers around here. There's one, but it's not close enough.
Starting now, we can spotlight your comments with hashtag KJB. If you're trying to get my attention or ask a question in our comment section, or if you have something to point out, let us know. Again, we're live here with Eagle 8 HD above State Road 54, that area of Pasco County, north of Tampa, west of I-75, and west of the Tampa Premium outlets for a suspect that has fled on foot after a failed traffic stop. The Hillsborough County Sheriff's Office saying that suspect was wanted on an accusation of burglary, attempted to pull over the Ford F-250. That 250 then, and there it is as we zoom in on it. That's the vehicle that deputies say attempted to ram an HCSO deputy's vehicle. The deputy was able to swerve out of the way, according to the release, and then that's when the pursuit began, stopping at this point. I'd be very curious to know how close behind deputies were when the when the suspect got out of the vehicle and fled on foot. You can see the door is still open in the field. Dozens, clearly. Because the odds, of course, of...
Well, it stinks that they stopped the... coverage of it, but I will... Let me see. Deputies comb Pasco County Woods. Developing story. Yeah, they don't have anything else on it right now. I'll keep an eye on it. If they end up getting coverage of it again, then we can take a look. All right, so let me keep my flight radar open along with the other 457 open tabs I have. Because what's one more? What's one more? Why not? Why not just... Let me close out all of this. Y'all, the number of tabs I have open on my computer is very representative of how my brain works. She's snoring. She's snoring. There you go. She's snoring. Look at her little belly breathing. She's snoring really loud right now. I love it when she snores. Bless her little heart. Bless her little heart. Okay. Oops. I forgot I have my scanner on. Scared me. Turn the scanner off. Okay. Let's watch the rest of Melanie Gibb. Let me get it pulled up. Remember listen to her little snore. God, it's the cutest little snore in the whole entire world. Okay, remember we left off yesterday. Oh, Lucy. Bless Lucy's little heart. She's so little bitty. Okay. Remember we left off yesterday. Melanie Gibb was testifying. She was doing her cross-examination, and it was getting a little heated. Her and Pryor probably not going to be besties after this. I don't see him getting invited to the portal parties, but what do I know?
Thank you. Please be seated.
What do I know? We'll do 1.25 speed because
We have all 18 minutes. Okay.
Because why not?
Okay, we're on the record again on case CR 22211623, State of Idaho versus Chad Guy Daybell. We're continuing with evidence this morning. The case in chief still presented by the state. The court notes that we do have all 18 jurors have returned and each have signed their juror affirmations this morning. So if we're ready to continue with evidence, it's cross-examination of Ms. Gibb this morning, who has returned on the witness stand. Is the state ready to proceed and have the jurors brought in?
Yes, Your Honor. Thank you.
From the defense?
Yes, Your Honor. Thank you.
Okay, we'll continue with that. And as I mentioned to counsel, we'll discuss as the day moves along what time we might conclude for the day, but we'll see how things are going in terms of length of this witness and the next. So if we'll go ahead and have the jurors brought in at this time, please, Mr. Bailiff.
Bring the jury.
All rise, please.
versus Chad Guy Daybell. We're continuing with evidence in the case. Ms. Gibb is on the stand, having been previously sworn yesterday. This is continuing cross-examination. The court notes the presence of all 18 jurors properly seated as well, and the court will also indicate that each of the jurors has completed their juror affirmation for the morning. So thank you all for following the court's continuing admonition and instruction in that regard. With that, if we're ready to continue with cross, you can go ahead and take the podium, Mr. Pryor, and we'll continue.
Thank you, Your Honor.
All right. Before you begin your cross, Mr. Pryor, I'll just inquire of the witness. First, I'll remind you, you are still under oath, Ms. Gibb, and I'll ask, did you review anything about the case or your testimony or discuss your testimony with anyone else since last night when we concluded? Okay. She indicated no. So with that, Mr. Pryor, if you'd like to continue with cross, you can do that now.
Ms. Gibb, I want to go over just a couple of preliminary matters if we could first to start there, if that's okay with you.
Okay.
The first thing is you never did provide a hair sample to any law enforcement agency in this case. Is that right?
Correct.
You never turned over your phone or was requested to turn over your phone to any law enforcement agency. Is that correct?
Correct.
You were never requested or did turn over any email or any email accounts or social media accounts to law enforcement at their request. Is that correct?
Correct.
You did, however, in 2021, provide a DNA sample to a Rexburg or a Fremont County officer a couple of years after this alleged incident. Is that right?
Correct.
Okay. Now, I want to talk to you a little bit about an organization that I think you're affiliated with called Seven Gatherers. Are you familiar with the term Seven Gatherers?
I'm not.
You're not? Okay.
There's that okay again. Okay. Okay.
Initially, there was some discussion about Chad and Lori. Obviously, we're getting very close during the early parts of January and February of 2019. Is that correct?
Yes.
Okay. And at any time, did they talk about having a plan to spend their lives together?
At some point they did.
Do you recall when that was?
I would say they kind of talked about it in the beginning of the relationship about being part of the head of the 144,000. I would say within a month or two. I'm not sure exactly the day.
Well, I appreciate the religious references, but I was talking more on a personal note that they were planning if when Tammy passed away that they were going to spend their lives together. Did you ever overhear that kind of a discussion?
I guess kind of. Yeah.
And on that note, we previously touched on the fact that Chad and a number of his speaking engagements prior to even knowing Lori Vallow spoke about his, and I want to use the right word, his premonitions, I guess, about Tammy not having a long life. Recall that?
Yes.
And you were present for at least a couple of those, correct?
Correct.
Okay. So it was also common knowledge that Chad had openly discussed the fact that he felt his wife was not going to live long well before he ever met Lori Vallow, right?
Right.
Okay. And in fact, you touched on that when you had one of your text message conversations with Prosecutor Wood. You had mentioned that, do you recall having that discussion?
It's possible, but I don't recall it.
Okay. Is it possible that you told him that Chad made it known to a lot of his close friends that he knew that Tammy wasn't going to live long?
Yes.
Okay. And we don't need to go into that. Okay. Now, at no time did Chad Daybell ever tell you that he intended to do harm to Tammy Daybell, did he?
Correct.
And in fact, at no time did Chad Daybell ever tell you that he intended to do harm to J.J. Vallow or Tylee Ryan?
Correct.
Okay. So this plan that they had to spend their lives together would only have occurred if either Chad divorced Tammy Daybell or that if the premonition was accurate and Tammy had passed away, that they would be able to spend their lives together, right?
Yes.
Okay. I want to go back to the discussion in late November when you claim that you got a call from Chad about not wanting to talk to the police, correct?
Correct.
Okay. Now, to put a little foundation in this, on the weekend of the 19th through the 23rd, you were at at Lori Vallow's townhome that night, right?
Are you talking about November?
September of 19th through the 23rd, you were at,
Yes,
I'm
yes.
just putting a little foundation in place. You were at there, and then part of that was to go to a seminar. There were a number of other things as well, right?
Correct.
Okay. So in your eyes, that was the last time that you saw JJ Vallow alive, right?
Correct.
Okay. And did you later come to learn that the prosecutors in the state's allegations are that JJ was murdered at or around the time that you folks were there for that podcast?
I wasn't aware of that.
You've never become aware of that?
I wasn't aware that they were murdered. I knew that the word was missing.
Okay.
Yeah.
And subsequently, you've learned that the allegation is that there's an alleged murder that took place at or around the weekend of the 19th through the 23rd. Is that correct?
Yes.
Okay. Now, your testimony is that Chad Daybell called you and said, don't talk to the police. Is that what it was on the 19th? And do you remember the date of that?
I remember it was 2 or 3 days before Thanksgiving. So it was in November, whenever the Thanksgiving was.
And would the 25th of November ring a bell, possibly?
It's possible.
Okay. Now, prior to November 23rd, did you have any phone conversations with Lori Vallow giving you a warning that Chad was going to call you?
No.
Okay. But when Chad spoke with you at that time, he did tell you that Lori was going to get a hold of you afterwards, right?
Correct.
Okay. Well, Ms. Gibb, isn't it true that on November 25th of 2019, Chad Daybell contacted you and specifically asked you, where is JJ Vallow?
No.
Okay. And yet, during that conversation, he told you that Lori was going to be contacting you, right?
That's right.
And then after that, did Lori contact you?
She did.
And what was the discussion, Ms. Gibb?
She told me that the police had come asking for JJ and that she had told them that I had JJ and that I needed to go to a movie called Frozen, take some pictures. Back. Yeah.
So your denial of the fact that Chad called you, you're denying the fact that Chad Daybell called you on the 25th, seeking out information as to where JJ Vallow is. You're denying that, right?
Yes.
Okay. But yet Lori Vallow calls you back after Chad Daybell and says, I need you to cover for me and tell that police that you have JJ Vallow, correct?
Right.
Okay. But Mr. Daybell also during that conversation said, you're going to hear from Lori.
Correct.
Did Lori ever tell you, I told Chad that JJ was with you and go along with this story?
I don't believe so.
Okay. But you don't know for sure, do you?
I can't remember. I can't recall all the words I said to her.
Okay. All right. Okay. Fair enough. And then was it that day or was it the next day that the police officers called you?
It was the same day.
Okay. And at that point, you told them that you had JJ Vallow, didn't you?
Not initially, but by the end of the day, yes.
Okay. You basically told them during that day that you had possession of JJ Vallow. Is that right?
I said I had him and then I didn't have him.
Well, no,
That's
we're
the
going to
words
go
I
one at a
used.
time, ma'am.
Okay.
Dang, he's getting
The first
sassy.
opportunity to have discussion with the police and discuss where JJ Vallow was, you told them you had JJ Vallow.
Correct.
Okay. So I'm having some difficulty with the fact that Chad's trying to cover something up. And yet after a phone call from Lori discussing to tell them that you had JJ, you suddenly go along and say, yes, I had JJ Vallow.
Objection. This is a narrative. I'd ask to strike.
Sustained.
All right.
He did this a lot yesterday.
And then at some
too, the
point
narratives.
subsequent to that point, you decided to tell the police, well, I lied about this because I was having an emotional issue with how to deal with this, correct?
Yes.
Okay. And how long did it take you for you to have that emotional reflection to go back to the police and tell them, well, I'm not going along with this lie that Lori and I came up with?
A few weeks.
Objection, Your Honor. Misstates the evidence.
Well, it's already been answered by the witness. It's late, overruled.
Okay. A couple of weeks it took you to decide that I better tell the police the truth, right?
Right.
Okay. And then at some point you said that you decided to go and excuse me. You decided to go to the police to let them know what really happened. And that was the 2 weeks later, right?
However many times it was, how many weeks, yes.
Okay. And then at some point yesterday, you testified that without talking to any law enforcement, you then took it upon yourself to record the conversation between you and Lori, correct?
Correct.
Okay. Now, Ms. Gibb, and that occurred on about the 8th of December of 2019. Does that sound correct?
If you're referring to the recording, yes.
Recording, yes. Does that sound correct?
Yes.
Okay. Okay. Do you recall having a call to Ray Hermosillo?
Yes.
Right. And what your testimony previously was, or yesterday, was that you didn't talk to anybody from the police department before you made that call, correct?
Objection, Your Honor, misstates the evidence.
Overruled.
You testified that you did not call or talk to anybody with law enforcement prior to recording that call to Lori Vallow. Is that correct?
Your Honor, again, I'm going to object. This misstates her testimony.
I'll sustain that objection.
Okay. Did you have any contact with law enforcement prior to making that recorded call to Chad and Lori?
I wasn't aware of the dates, so I'm not sure exactly when those dates were.
Oh, so are you saying you did talk to law enforcement?
I did.
Oh, prior to it, right?
I'm not sure of the dates.
Okay. Well, would it refresh your recollection that there were 2 calls to the Rexburg police with Ray Hermosillo on the 6th of December and the 7th of December? Does that spark your memory a little bit?
No, I don't recall the dates.
Okay.
It's just your memory, not mine.
Okay. And you don't have any recollection of talking to the police beforehand then, right?
Beforehand, what?
Before you recorded the call to Chad?
I could have, or after, or before. I didn't recall the timing.
Well, isn't it true you testified yesterday that you didn't talk to the police when it was inquired?
Objection, Your Honor, that misstates the testimony.
Sustained.
So you did talk to the police on the 6th and 7th with Ray Hermosillo by phone before you made that phone recording to Chad and Lori, right?
Objection, Your Honor, asked and answered. She's already said she doesn't recall the dates.
I'll overrule that if she has any additional answer.
Ma'am?
You want to repeat the question, Mr. Carter?
There was contact with law enforcement before you made that recording, right?
There was contact. I don't recall the time.
Okay. And you don't even recall the date, right?
No.
Okay. All right. Now, during that phone call, I touched on this yesterday a little bit. And Lori's comments on the phone call were, I had to move her somewhere else. You recall that?
Sounds familiar, yes.
I will do whatever the Lord needs me to do.
Right.
I love you so much. I know, and you said, I know you do, right?
Correct.
Okay. Now, I noticed during the phone call that the majority of the conversation was between you and Lori. Would you agree with that?
Yes.
And that the only time Chad got on the phone call is when he was talking about, his premonition about Tammy, and that he feels that someone's trying to jump on him as a result of this issue between you and Lori. Would that be fair?
Objection, Your Honor, the call speaks for itself and that misstates what was in the call.
Sustained.
Okay. But you would agree with me that Chad was really not a primary or significant portion of that call, correct?
Yes.
Okay. Now, one of the things I took note of during the phone call was that Lori made the comment, you more than anyone else knows the truth when she was talking to you. Do you recall that?
Yes.
Isn't it true, ma'am, that was a way for her to hide the fact that, Ms. Gibb, you and Lori Vallow know the truth about what happened to JJ Vallow on the 23rd of September, correct?
No.
Okay. How about the 22nd of September, ma'am?
No.
Okay. Isn't it true that Lori was being very vague on that phone call because Chad was there and she didn't want Chad to know that you were going to talk about the murder of JJ Vallow?
I have no idea what her agenda was.
Okay.
That okay is so that tone.
Now, ma'am, there's been some reference to names, people using different names, Chad, Lori, yourself, and the name James and Elena came up, right?
Yes.
You're familiar with that?
Yes.
Are you also familiar with the fact that that was a novel that Chad was writing about his relationship with Lori Vallow?
Yes.
Okay. So that all of that discussion about James and Elena was Chad using one of his personal experiences, maybe not a proper experience, but an experience about his relationship with Lori, and he assigned names to those two folks, correct?
I wouldn't know his agenda.
Okay. Now, you also had a nickname as well, right?
Yes.
Phoebe?
Yes, that sounds familiar.
You went by Phoebe? It's
very
Tampa Bay
occasionally.
trusts the only news station that's on your side. News Channel 8. From
And Judge, this slide I'm about to show comes from Exhibit 7D, which was previously admitted by stipulation of the parties. I can show it to counsel if you like. Talk about the Elmo, and I'll try to navigate through that if I can. We'll see how well we do there.
Is this Defense Exhibit 70?
It is Defense Exhibit 7, Judge, and subsection D.
7. Okay.
7, I'm sorry, 7.
That Elmo has both a light and a zoom in out feature on it, Mr. Pryor.
Warming up, Judge.
Chopper is moving south instead of doing the same circles. I wonder if they've got reports of him being down
Perfect.
here.
Can I have you stand here for me? Okay. So you previously discussed the fact that you never talked about dark portals or dark lives and things like that, correct?
Well, I didn't go around teaching them to people that I can recall.
Okay. Well, this is an email. I'll represent this as an email from Lori Vallow to you, and it says Phoebe. And then you responded with the email below, and I apologize for the print on there, but if you could read from thanks and go down to the bottom to me.
Thanks. I love you so much. I'm going to teach you right now, teaching about discerning and shutting off dark portals.
Now, I will represent to you that that was an email that was put together, and it was from you to Lori Vallow. Do you recall that?
I don't recall that email.
Okay. But in that email, you're talking about teaching people about dark portals. Correct?
It sounds like she said she was going to teach me.
Do we need to look at it again? Judge, can I approach the witness with the exhibit?
If you've got a printed copy, you can have the bailiff take the exhibit to the witness.
Judge, may we approach briefly?
Yes.
I have been trying to keep an eye on the manhunt. There's no coverage of it, but I'm watching the choppers to see if they come back on. But the chopper that was circling is going down south now.
Yes.
Mr. Bailiff, could I have that returned to me, please?
That exhibit, Mr. Pryor, based on sidebar, we're going to designate Defense Exhibit 7C is what was just published to the jurors and given to the witness.
Now, Ms. Gibb, the date of this email from Lori Vallow to you was dated 7/25 of 2019.
Okay.
Okay. And at that time, you were in the process at about that time, very time, on the way to a mountain retreat camp to teach that in the next few days, right at the time you sent this, correct? Remember that?
No,
You don't remember that?
I don't remember anything about me teaching anybody anything like that.
Okay. So you're denying the fact that you and Ms. Vallow had a conversation and you talked about teaching and shutting off dark spirits or dark portals, right?
Incorrect. She shared that.
Oh, she shared that with you.
No, that text says that she wanted to teach me. It had nothing to do with what I responded to that I can see from that text.
Well, forgive me, but the text says, I'm going to teach right now, teaching about discerning and shutting off dark spirits. So it's your contention then that you're not Phoebe, right?
Well, I gather from that conversation that she was sharing that with me.
Okay. Well, I gather from the conversation that you were sharing that with her. So we have a disagreement, don't we?
Objection, Your Honor, argumentative.
Sustained.
Okay. So your position is you never talked or taught in any camp Is that right about dark portals? Is that what you're
That's
testifying to?
correct.
Okay. Now, you also previously testified that you never discussed dark and light or super dark or different levels of dark and light. Is that right?
I discussed it at times with probably people in the inner circle, but I didn't go around teaching it that I can recall.
I didn't ask about teaching. I said that you had discussions with people about light and dark then, right?
Right.
So that's not a term that's not unfamiliar to you, correct?
Correct.
Okay. So when you say the inner circle, does that include Mike James?
No.
Okay. So you never had a discussion with Mike James about super dark and dark. Is that right?
Not to my recollection.
Okay. Would it refresh your recollection that on November 12th of 2019, you contacted Lori Vallow complaining about Mike James and someone named Nancy being super dark? Does that refresh your recollection?
I don't recall that.
Okay. And if I were to show that to you, would that help you refresh your recollection?
It doesn't matter to me. Regardless, I just don't recall it.
Okay. Well, Mr. Bailiff, could you provide this to Ms. Gibb? Ma'am, when you're done reading that, would you set that or give that back to the bailiff, please?
They must have either found the guy or given up because that chopper's going all the way back down.
Okay.
Give it back to the bailiff, please. Mr. Bailiff, if I may, please. So you saw this. Does this refresh your recollection, Ms. Gibb?
No,
It doesn't.
I don't recall.
Okay. Well, do I need to show it to you again and ask you?
I can read it and I see what it says. I just don't recall that text.
Okay. So you don't recall talking about Mike James and asking for a favor and mentioning that someone named Nancy is super dark, but obviously there was that conversation, right?
According to that text, but I don't recall that text.
Okay. And talking about being violent and bad language.
Yeah, I saw that.
Okay. You're not denying that this text exists, are you?
No, I just don't recall it.
You just don't recall talking about super dark. So when you gave your testimony that you never really preached or talked about super dark or super light or anything like that, is that still accurate?
I don't recall talking to people outside of the inner circle about that.
Okay, well, that's Mike James, and you just told me Mike James is not in the inner circle.
He's not.
So that's somebody you were talking to Lori about, and it was based on a discussion about light and dark, right?
Right.
So you did talk outside your inner circle about this, didn't you?
Incorrect.
Incorrect? Well, Mike James isn't in your inner circle.
No.
Mike James is unloading on me and says Nancy is super dark. So are you suggesting that, it was just Mike James saying the super dark and you were just listening? Is that what you're saying?
I don't recall how I felt at that time or what he was saying context. I just have no memory of that. I'm sorry.
Okay. And your lack of memory is
Objection, Your Honor. Argumentative. These have been asked and answered, and this is a narrative.
This last question was not a question. It was argumentative. It's sustained.
Judge, and I think I'm going to move on. Okay.
Sure.
You mentioned about castings.
Right.
And it's your testimony that prior to meeting Lori Vallow, you never engaged in castings. Is that right?
Right.
Okay. But then when you met Lori Vallow, you started the process of engaging in castings.
Correct.
And you mentioned that as part of castings, physical violence to anyone was never part of the solution there, right?
Correct.
The solution was to engage in castings and pray to have evil spirits leave the body of the people you believe are possessed.
Correct.
Death was never in the equation for castings. Is that right?
I guess they eventually said that they would pass on if the evil spirits would leave.
So is that something that's consistent with your LDS faith?
No.
But you engaged in that conduct, right?
Correct.
Okay. Did anybody force you to engage in that conduct?
No.
Okay. I'm going to switch gears a little bit. We previously talked about you going to Hawaii to visit Lori in 2019. Okay. Did Lori pay for your flight on that trip?
I don't think so. I don't recall.
Don't recall, right? Okay. but Tylee was not there. That would you recall?
Not when I was there.
There were occasions when Lori would pay for people's flights. Do you recall that ever occurring?
I don't know.
Okay. Do you ever have a discussion with Lori about paying for Chad's flight to speak in Arizona?
Doesn't sound familiar.
Okay. I want to go back over the timeline a little bit about the weekend of the 19th through the 23rd. Okay.
Okay.
You arrived in Idaho Falls on the 19th. Is that what you recall?
Yes.
That was a Thursday, right?
Yes.
Okay. Lori picked you up at the airport. Is that correct?
Yes.
Was Alex there as well?
He wasn't in the car. No.
Okay. You also, on that Thursday, in a previous interview with law enforcement, mentioned that you went to a restaurant immediately upon arriving in Idaho Falls on that Thursday.
That's right.
And that restaurant, if I recall, was a Johnny Carino's. Does that ring a bell?
I just know it was an Italian restaurant.
Okay. Okay. At that point, was JJ with you too when you went to Johnny Carino's?
I don't recall seeing him there.
Okay. Do you recall that Lori had hired a babysitter that day?
Yeah, I think so.
Right. And Alex was with you because the JJ was with a babysitter, right?
I believe he met us at the restaurant.
Okay. Okay.
Okay. Okay.
Okay.
Okay. Okay.
Then after you were at the restaurant, do you recall that the two of you then went to a Walmart?
I don't recall.
Okay. It's possible you went to a Walmart afterwards, right?
It's
always a
possible.
Walmart.
Okay.
It's always a Walmart.
And then you, after going to Johnny Carino's and going to the Walmart, it was relatively late that night, correct?
I feel like it was in the afternoon.
Okay. Is that what you recall?
Yes.
Okay. But then is it your testimony that the remainder of the day you and Lori spent time together, you didn't see Chad, correct?
I don't recall if Chad came over or not. I just know I was with her.
Okay. And that was Thursday, correct?
Yes.
Okay, so then we move on to Friday. Do you recall going to a place called the Gravity Factory on Friday?
Some jump place.
I think that's what that was,
Yeah,
right?
I do recall going there.
Talked about that with law enforcement, right?
Yes.
I think you called it like a jump house or something like that.
Like that.
Do you remember about what time you folks went to the jump house on Friday?
Well, I'm not sure it was Friday, but it was daylight outside.
Okay. Well, we know that it wasn't Thursday because we already discussed Thursday, correct?
I can't say if it was or wasn't. It could we could have done it on Thursday.
You could have.
Yeah, I don't recall when we actually went.
Okay. So you recall telling law enforcement in an interview that on Friday you went to the jump house or to the Gravity Factory? Do you recall telling law enforcement?
I don't recall the date I shared with them.
Okay. And you don't recall what time you went to the Gravity House or the jump house, right?
Correct.
Okay. Okay. On the Friday morning, do you recall going anywhere Friday morning?
I just know specific things we did. I just can't always recall exactly what day it was.
And then do you recall that after you had spent amount of time, before we get there, the jump house, that wasn't for you and Lori, right?
Correct.
That was for JJ?
Correct.
Okay. And you don't recall the number of hours you spent at the jump house, do you?
I would say it was maybe around 2 hours.
Okay. And that was, and my recollection is that was in Idaho Falls, correct?
I don't know where it was.
Oh, you don't remember?
I don't.
Okay. And then after the jump house, you and Lori and JJ was, oh, by the way, was Alex there too at the jump house with you guys?
I remember he came and went. He brought some pizza, I believe.
Well, you guys went out for pizza, didn't you?
Yes, we did. Yeah.
You didn't bring pizza.
I feel like he brought something in. That's just my memory.
Right.
Yeah.
What happened is you went to the jump house and then, isn't it true, you afterwards Alex came by and then all of you went out to have a bite to eat for dinner at a pizza place, correct?
I don't recall what day it was, but we did go out for pizza one night.
And then after you went out for pizza, you went back to the townhome, correct?
I don't remember.
Okay, well, you went back because you had to gather your things to go pick up Dave, right?
I didn't have to pick up Dave.
Well, who picked up Dave?
No one.
He drove in?
Yes.
I was under the impression Dave flew in.
No.
Okay.
Okay.
That Dave flew in. That's not correct?
That's not correct.
Okay.
Okay.
And then on Friday evening, the folks in the townhouse that evening were you and Dave,
Correct.
your boyfriend at the time, Lori and Alex,
Yes.
and JJ.
And JJ. And I think Chad was there too.
Oh, how long was Chad there?
I don't recall.
Okay. Is it possible that Chad wasn't there?
It's possible.
Okay. And then do you recall if Alex and your boyfriend at the time were playing Guitar Hero on a video game?
They were playing. I remember watching it. I might have at some point just jumped in a little bit and danced a little bit.
Okay. We don't. That's okay.
Mhm.
But the two of them had spent a considerable amount of time that Friday night playing Guitar Hero, Alex and Dave, correct?
No, I don't believe Dave ever did.
Oh, Dave watched Alex play?
Yes, I guess so.
Okay. And then we go on to Saturday. You got up in the morning and prepared to go to this firm foundation thing, correct?
Correct.
Okay. Now, do you remember in one of your text messages to Prosecutor Wood that you mentioned that you were there at the firm foundation for about 10 hours taking pictures? Do you recall talking to Prosecutor Wood about that?
I don't recall talking to him about that.
Is it possible you spoke to him about that?
It's possible.
Okay.
Okay.
So you were at the firm foundation and you said you were there for about 10 hours, correct?
I think I was. I just don't remember.
Okay. And do you recall that it was rather late at night on Saturday when you got done with the firm foundation?
Yes, yes.
And you didn't see Chad that night either, did you?
I don't recall seeing him.
Okay, right. So then we go on to Sunday. And you and Dave slept in that morning, correct? Recall that?
I do not recall that.
Okay. Anyway, you woke up late, apparently, and Lori,
Objection, Your Honor. Misstates the prior testimony in counsel's. It's a narrative.
Sustain.
is it possible you slept in till late Sunday morning?
No,
It's not possible?
I don't sleep in.
Okay, thank you. Okay. And then, do you recall that Lori gave you a haircut that Sunday?
Yes.
Okay, and how long did that take?
A few hours because she colored my hair too.
Okay, so that was Sunday morning, correct?
I think so.
Okay, and do you recall about what time that was?
I don't.
Okay. Sometime in the morning, right?
Correct.
Okay. And then you folks went to have lunch that after she cut your hair, correct?
No, I don't remember that at all.
Okay.
Okay.
Did you stay in the townhouse and bring lunch in?
I don't remember how the food was. I don't remember her having a lot of food. She might have made something. I don't remember.
Okay, but at that point, you hadn't seen Chad Daybell Sunday morning, correct?
No, I saw him Sunday morning.
You did? When was that?
Shortly after we went to this field behind a church building. So sometime in the morning. I felt like it was in the morning. Could have been late morning, but it was sometime.
Do you recall discussing with Lori that after Chad gets out of church Sunday afternoon, we'll go out and look at a piece of property? Do you recall having that conversation with Lori?
I don't recall, but it's possible.
Okay, so is it possible you're just confused about the facts and the time to go visit the land was really early to late afternoon on Sunday?
I felt like her seeing that piece of land that I talked about first, and then going to see that land for sale was second. That's just my memory.
Oh, so you went to see a piece of land with Lori first?
Well, I wouldn't consider it was just this empty field that was behind a church, but it wasn't for any purpose of being purchased.
So you were traveling to the piece of property that you were going to go look with Alex and David, but you were traveling with Lori at that point, correct?
Objection, Your Honor. Misstates the testimony. It's a narrative. I'd move to strike.
Overruled.
You were traveling with Lori to go look at the piece of property with the real estate person, correct?
No.
Who were you traveling with?
I don't know who I was traveling with. I think maybe Dave and I were in the truck and we drove over there. I don't remember.
You don't remember. So it's possible that you were traveling with Lori as well, right?
No.
Okay. So you remember you weren't with Lori.
Yeah, I remember.
Okay. But you had mentioned that you and Lori went to see a piece of parcel first.
Yes.
Okay. And then subsequent to that, you went to look at another piece of property, correct?
Correct.
And then Chad was meeting you at that second piece of parcel, correct?
Correct.
And then do you recall you told in an interview to law enforcement that Chad was still in his church clothes at that point?
Could be.
Okay. Well, do you remember that or not?
I don't remember the conversation.
Okay. So it's possible that you told law enforcement that Chad was in his church clothes in the afternoon when he went out to see the property, correct?
Correct.
Okay. So you did see Chad at the property at that point, correct?
Correct.
And that's the one we're really sure about, right?
I'm sure about both of them, but yes, he was at that one.
You're sure? Which is the other one that you're so sure about?
The one that we just talked about, the prior one,
Prior one about what?
the parcel that we went to first.
Okay. Oh, Chad was there too?
Uh-huh.
Okay. And then afterwards, you went back to the townhome, correct?
I think so, but I don't recall for sure.
Okay. And Chad didn't go with you back to the townhome, did he?
I don't think so.
Okay. And then at that point, you were getting prepared for your podcast that you were going to do that night, right?
We didn't prepare for that till the evening.
Okay. And again, on a Sunday evening, Chad wasn't there for the podcast, correct?
Correct.
And then just to clarify again, after you did the podcast that was late in the, well, it could have been as late as Saturday or Monday morning, but it was after midnight sometime, right?
I'm not sure if it was after midnight. I just know it was around that time.
Okay. And then and then we'll move on to Monday. And Monday, you departed and left to go back home. Is that correct?
No.
What did you do on Monday?
Dave and I drove to Pocatello to see his son.
Okay. And you left at about 9:30.
That sounds about right.
Isn't it true that you and Alex and Dave drove by Chad's property Monday morning?
No.
Okay. Judge, I have nothing else. Thank you.
All right. Thank you, Mr. Pryor. Ms. Blake, you can conduct redirect if you'd like.
No, that's already up there. But it has to be. It's going to be put in. Yeah. That's right.
Or it's a part of it. Yes, we'll get that straight.
From the years of 2018. We've asked you a lot of stuff from the years of 2018, 2019. Have you done your best to recall the facts?
Yes.
With regard to Lori, we talked about your relationship with her. And at times, I think you indicated you had daily contact.
Right.
And at times it was more sporadic.
Correct.
But this contact with her spanned over a period of time, correct?
Yes.
You were asked if you thought Chad believed that he could see visions. And I think you said, yes, that was your understanding.
Yes.
Did Chad ever indicate to you that he had visions?
Well, he shared them publicly. So yes.
So Chad shared that he did have visions.
Yes.
Welcome.
You were asked yesterday about the term vibration.
Yes.
Did Chad and Lori ever use the term vibration?
Yes.
How did they use it?
They used it in a way to express their what they thought their knowledge was about being translated.
And when we talk about that, did your level in translation equate with the vibration number?
Yes.
What did they teach regarding that?
So the higher the number, the closer to the body being in a translation state.
And what did they talk about in relation to a translated state?
Your body would be changed in a way that you wouldn't have to eat or, I don't know, drink, but I don't know, your body's just more, I guess, stronger, powerful.
And you wouldn't need some of the things that, generally speaking, mortals or bodies need to survive. Is that fair?
Yeah, yeah.
You were also asked some about light and dark, and you were asked about energy work as well. Do you recall that?
Yes.
Is it fair to say that some people may have a glow
Judge, I'm
about
going to
them?
object. It's leading.
Sustained.
Your Honor, and I think, if I may respond,
Well, you can ask another question, but it is redirect, not recross, so that was the leading question.
I guess that's what I wanted to be heard on.
Go ahead.
I think there was some agreement to allow defense to go outside the scope of direct, and I do think questions were asked that opened this avenue.
Judge, can we approach?
That's not necessary. I'll make a ruling. There was some discussion, and to the extent that there was additional cross outside the scope of direct, then it would be appropriate for leading on your redirect, Ms. Blake, on those topics. So I'll, after reconsideration, overrule that objection because it was a topic essentially brought up anew in cross. So I will allow some leading, Ms. Blake. So go ahead.
Thank you, Your Honor. Would it be fair to say that some people may have a glow about them?
Yes.
And is that a little bit different than the light and dark that Chad and Lori taught?
I think so.
You were asked about your communication with the prosecutors.
Yes.
And you acknowledge you had communication with the prosecutors.
That's right.
Did anything about that communication alter your memory of the events?
I'm not sure what you're saying.
Sorry. Did it change what you recall from the events with Chad and Lori, your communication with the prosecutors?
Well, no.
Did you ever personally observe Lori and Chad on the phone together?
Yes.
And were you with Lori when those conversations would happen?
Yes.
Were you ever able to overhear some of the conversations?
Just a little bit.
After Lori would get off the phone with Chad, would she ever tell you what they talked about?
Yes.
And when she'd tell you what they talked about, would she share with you things Chad taught or told her?
Yes.
And you were asked about in these, whether or not Chad had ever indicated to you that he intended to physically harm Tammy. And I think you said he'd never indicated that.
That's right.
And you also said he never indicated a specific intention to harm Lori's kids. Is that correct?
Yes.
Who was it that would label someone dark or a zombie again?
Chad.
And and once someone was labeled a zombie or dark, what was going to happen to their body? As Chad and Lori taught it.
If they could cast the evil spirit out, the body would naturally die.
So if someone was dark or a zombie, they were going to die.
Yes. Well, maybe. I mean, not everybody. They knew.
But that was the teaching. If the casting was successful, the body would die.
Right, right.
And JJ was labeled darker zombie.
Yes.
Tammy was labeled darker zombie.
Yes.
Charles was labeled darker zombie.
Yes.
And Tylee was labeled darker zombie.
Yes.
You were asked about that phone call, the recording from December 8th of 2019.
Yes.
And to be clear, did law enforcement ask you to record that?
Never.
Do you recall hearing Chad on there telling you that you may be in danger?
Yes.
As Lori talked, did Chad ever jump in and correct her? That you recall?
Say that again.
Did Chad ever jump in to correct Lori when you were on that call?
I don't recall that.
And Chad was there with her for the call. We could hear him, correct?
Correct.
And Lori tells you JJ's okay.
Correct.
You were also asked about when Chad called you around Thanksgiving. Do you
Yes.
recall that call in 2019?
Yes.
Do you recall what Chad told you or asked you to do at that time?
He asked me not to pick up the phone when the police would call.
Do you recall asking him if JJ was with Kay?
Yes.
And what was Chad's response?
No. The answer was no.
So Chad knew he wasn't with Kay.
Yes.
When that phone call was placed to you by Chad, did you know JJ was missing at that time?
I guess, no, I didn't.
So when Chad first tells you not to talk to the police, you actually don't know JJ's been reported as missing.
Correct. Yeah.
I have no further questions.
Judge, I have just a couple of items on recross.
Okay, that's fine. Mr. Pryor, I'll allow some recross.
And Your Honor, may we approach?
Yes.
Skipping through the talking.
Scope of recross, please keep it on those topics and you can continue. With the microphone, Mr. Pryor, please.
Hey, Judge. Ms. Gibb, you talked about the fact that you participated in castings, correct?
Correct.
Okay.
Thank you, Jackie.
And as part of your participation in castings, you knew the intent of what a casting was used for was to rid the body of evil spirits, correct?
Correct.
But then you just testified with the prosecuting attorney that you also knew that at successful completion of the casting, the human body would die. So you knew that when you were doing this castings, that apparently you were ending the life of a human body. Isn't that correct?
I had no idea what really the result would be.
Oh,
That was
okay.
the theory.
Okay. But you just said that the purpose of castings was to, when the prosecutor asked you about that, that it would end the life of a human body, correct?
Objection, Your Honor. Misstates the testimony, misstates the prior question from the state.
Sustain. All right, that concludes the recross then. That will conclude the testimony of Ms. Gibb. I believe she's under subpoena from the defense also, but I don't know that there's nothing covered that where I allowed the extended scope of cross. Do you intend to recall her, Mr. Pryor?
Judge, I want to keep her under subpoena at this point because if other issues come up and I need Ms. Gibb to come back, I spoke with the prosecutor about how I can communicate with Ms. Gibb if that need arises. But at this point, I want to keep her under subpoena. I would ask the court to do an admonishment about not allowing her to view anything or talk to anybody about the case. But at this point, the final decision has not been made. And I explained that to the prosecutor. But in the event something comes up that I need to revisit that, I need to have that opportunity.
Very well. Ms. Gibb, that concludes your testimony for now. You may be recalled because you may be recalled and are under subpoena from the defense. I'll request and admonish you, not request, but you're admonished not to watch further trial proceedings that may be available on the live stream or to follow the case in any way until such time as you're released from the subpoena. Okay. All right.
Judge, could I also inquire that Ms. Gibb be advised about discussing her testimony or testimony with anybody else?
That's part of the admonishment. So
Judge.
that will conclude the testimony of Ms. Gibb. We're going to take a mid-morning recess and discuss scheduling as well as take up one issue outside the presence of the jurors. So at this time, we will break for our mid-morning recess. All right. Keep sit down. All right, Ms. Blake, I understand the state was interested in putting an objection on the record relating to the manner in which recross is being permitted.
Yes, Your Honor. We had asked to approach in a sidebar about that. At this juncture, Mr. Pryor has been allowed to do a recross on almost every one of the state's witnesses, and I think it's extending beyond any new matters that may come up. So we're just objecting to the generality of him getting to recross and would request that it be limited to only if a new issue arises so that we don't end up in a situation where then the state asks to do another redirect and go down that.
And if I could respond, Judge Meade.
You may.
And quite frankly, Judge, it's not the prosecutor's prerogative, or is it their decision to decide when I get a recross? That's the judge's decision to make. So I don't know where Ms. Gibbs thinks she has the authority or the ability to say when.
Ms. Blake.
Ms. Blake is what I said, Judge, I think. I did say Ms. Blake, did I not?
You said Ms. Gibbs.
Ms. Gibbs. I apologize.
Go ahead.
Ms. Blake has the ability to dictate when this court makes its own independent decision when I'm permitted to have recross.
All right. Well, evidentiary rulings and the way witnesses are examined are subject to rules as well as the court's discretion. Certainly the state can lodge an objection and I'll pay attention to that. There is limitations on what is supposed to be allowed in the scope of redirect or recross. Part of the reason the court has been pretty liberal in allowing that is sort of I understood, standing agreement between the parties that with certain witnesses, instead of calling them twice, once in the defense or in the state's case, again in the defense case, for efficiency purposes, getting them on the stand once. I permitted extensive on some witnesses scope of cross beyond direct. If we are not going outside the scope as part of that agreement, then I would agree that it's not proper to allow recross every time. So I'll just watch for the topics that come up. And if we extend on cross beyond the scope and that's allowed, then that's where I think there's a second opportunity. So both sides essentially get a right to direct and cross a witness. So I'll just take that under advisement for future rulings. Any questions on that ruling, Ms. Blake?
Thank you, Your Honor. And the state does recognize it's clearly within the court's discretion. If we do have concerns in the future about a request for recross, would the court just like us to approach and then discuss that?
I just don't think those are prejudicial for the jurors, and approaching slows things down. So just
So
go
just
ahead
make the
and
objection?
just make an objection. I think unless it's related to some specific topic that may prejudice the jurors, let's just move it along with.
And the state does agree that recross may absolutely be appropriate. It just seems that it is at times just rehashing the same stuff.
Very well. It'll be under advisement for future rulings. We'll take our rest of our recess at this time. And I do want to just briefly discuss the remaining schedule for today with council right now on a sidebar, and then we'll take our break.
All rise.
I can't do a full day today, but we're going to see who's next because I don't want to miss some of the good ones. But let's see who. Wait, why is he laughing? Hope his chair breaks.
All right, we're back from the mid-morning as the state's prepared to call. Is that correct?
That is correct, Your Honor. The state will call Doug Hart.
Very well. You can call your witness.
This next slide is a continuation. I'm just going to pause to give the jurors a chance to read through
Communications are
about them. That
We have advised the jurors previously we might be stopping early today. Ms. Blake, is this a good time for us to break until?
So it looks like it's some of the research stuff. I wanted to make sure we didn't miss the kids. All right, I know it's only a 4-hour stream, only 4 hours. But I have a lot of stuff I have to get done today, and I have a meeting this afternoon. So I am going to have to call it a day for the live. Gibb is the bane to Pryor's existence. They don't like each other. There's no love lost right there. No love lost right there. They don't like each other at all. At all. Did Crocodile Tears get sentenced today? Yes. If you fast forward to the end, no, that's not right. If you rewind to the beginning, then you'll see it. She was late. I guess her busy prison schedule, got in the way. But it started late. But they did get her sentenced. So it was a doozy. Look, you can see the camera is like on Lucia's, like, hold on. You can see, every once in a while the camera will move, like you can see my flip-flop sitting right there and like the wheel of my chair. Every once in a while it gets moved. It's like what do they call it, the fourth wall? And then I'm moved. Oh wait, oh look, oh, there I am. There I am. Everything's off kilter. Everything's off kilter. So, I know, I feel like I'm so busy lately. So busy lately. And it's not going to calm down until Karen Reed is over, unfortunately. But I don't know. It'll be all right. So I am not sure yet about the Sunday. I will talk to the mods about Sunday and see if we're going to do a members only on Sunday. I will find out, and I will post it on the community tab when I talk to them. I'm trying to figure it out. I've got so much stuff going on. So I will try to talk to them, see who can do what and when. Bedtime is no later than 10 p.m. tonight. That's a good idea. I need to set myself a bedtime tonight. I am functioning on little to no sleep. There was one night this week that I got sleep. What night was that? Wednesday? Tuesday? I don't remember. So I'll find out about Sunday. All right, Marie Moss, our official statistician. Statums. Witnesses 2. Sidebars 2. Okays 32. 32 okays. He said okay 32 times in just that short time that we listened to that part of his cross-examination. That's crazy. 32 of them. Okay. That's what it reminds me of. Okay. And a whole lot of condescending and narratives. Oh, he loves the narratives. Don't he just love him some narratives on a cross-examination? Woo! That's all right. Okay. It reminds me of sure, Jan. Every time he says okay, that's what I think of is sure, Jan. Lord of mercy. Ooh, Mr. Pry. He does not like him some Melanie Gibb. Does not like him some Melanie Gibb, but that's okay. That's all right. All right, y'all. Have a great weekend. Monday, we have jury selection continues in Karen Reed, and I am going to do a big... I am shedding. I am losing my hair. I would not do well at a crime scene. At all. Monday, we are going to do a big Karen Reed crash course on all the stuff that we have gone over so far. We're going to rewatch some of the old hearings and talk about the motions and all of that stuff and get ready to go into this trial. We are going to go into this trial with open minds, ready to hear the evidence and see what we figure out. So we are going to go over everything that we can fit into Monday, possibly Tuesday. Look, we could have openings potentially by Wednesday, maybe, if they can get the jury seated on Monday. I have is it Yellow Cottage Tales. His name is Kevin. It's Yellow Cottage Tales. Has asked me to be on a Karen Reed thing tomorrow night. I am trying to swap some stuff around to see if I can make it work. If I am going to be able to do it, I will let y'all know. If I can't, then I can't. I don't know how much more I can fit into my schedule right now. So we'll see. But if I am going to be on there, I'll let you know. He's doing a thing. It's actually a really cool idea. He's doing a thing where he's having a bunch of people who've been following the Karen Reed case that are going to be on there. I think everybody's like, he said it's going to be like a 5 to 10 minute, like, plead your case to the jury type thing, which I think is great. There are some creators who are absolutely convinced that she is innocent. There are some that are absolutely convinced that she's guilty. Since I'm neither, I don't really know what pleading my case would be, other than I have been very clear, because I'm open until the end of trial. I have been very clear that this investigation is BS. The court documents and stuff are BS. There have been so many problems, and there's no way to, I would say there's no way to debate that, but man, they do. I'm getting attacked left and freaking right by people who are, everybody thinks they know what I think. People don't know jack. And I haven't had a lot of sleep, so I'm just about to go off on all of them. It'll be fun. Fun Friday. Fight the Trolls Friday. Woohoo! Just joking. All right, y'all. I will see you sometime. They don't know. They don't know. very few people know what I think. We're up to 4 now. There was only 2. We're up to 4 now. You're going on there with YCT. I have faith in you. Just watch his traps and temper. I've heard that about him, and I don't even know if I'm going to be able to make it work. If I don't even know. I am trying to, it is hard. Like, it's hard to fit anything else into everything I've got going on right now. But then I don't, and then people are like giving me crap for that. How dare you not go on this show and this show and this show, but you did this show and this show. Y'all, I've turned down a lot of crap. I can't like, go everywhere. And the places that I've gone, I've turned down some shows on both sides. Some of them because that ain't my scene. I don't want to go on the shows where people are just hateful to each other. That's not my scene. It's not my jam. And then some of them, most of them lately, within the last few weeks especially, it's just because I just haven't had time. So, but everybody knows everything on the internet. Everybody knows everything. So if I don't have time for something, then all of a sudden it's, they think they know why I said yes to this and no to this and whatever. It is crazy out there. Crazy out there. If I didn't have to do social media stuff for this, like because of this, then it'd have been gone a long time ago. It'd have been gone a long time ago. So, I don't know. I don't know if I'm going to be able to make it work. If I can't, then everybody should check it out anyway. It'll be interesting to watch, seeing everybody who has very, firm beliefs, plead their case. But, it's interesting. I tried really hard to keep some of the toxic stuff down in this, but man, there's none of that. There's none of that. It's just it just is what it is. So I won't be a part of it, but I'm also not going to continue trying to reach out to all these people and say, hey, can you work with me to calm all of this down? Because they tell me yes and then they don't. So, whatever. Yeah, stay off Twitter, your mood will improve. It's crazy. It's crazy out there. Crazy. But, people can say what they want to about me. I don't really care. I know that I know the truth. He was previously a Reed supporter and reasonable, then flipped to their side. Got in a fight with Turtle Boy and later a fight with Sean McDonough. Sean McDonough is it McDonough? McDonough. He's another one that his mod had reached out and asked me to come on there. I just haven't had time to fit anything else in. So, but I am going to do what I could do when I can do it, and then everything else will work itself out. So, but I will not be bullied into shutting up about how bad this investigation is. I will not be bullied into shutting up about the things that don't make sense, and I will not be bullied into changing who I am. So, all y'all can take that for what it is. Take that for what it is. Yeah, Nikki, I've noticed that a lot. It's true. All right, y'all. I have so much to get done today before my meeting this afternoon, so I am going to call it a day. I appreciate y'all hanging out with me. We got to see the sentencing this morning. So justice for Sweet Destiny. Thoughts and prayers with Gavin, man. That's going to be it's tough for him. Sad situation. So, and we got to see Portal Princess's former bestie. So that was always entertaining. All right, y'all. I appreciate it. I will see. Oh, look, she jumped up. I said, all right, y'all. And she knows that means she's about to go OUT. She knows. You see her jump up? She's a smart dog. You heard me. All right. I love y'all, and I will see you sometime.
Yeah, I gotta go. I can't stick around here forever.
Everybody was wonderful. Everybody behaved. Everybody's always so nice to me.
Just love your channel and
Goodbye, good people. Now, how the heck do I get out of here?